नहीं दोनों अलग अलग टाइप का
This I have taken concept from the opponent project. Actually, I was supposed to produce one record from CNBC. I don't know, no 24. I was directed to produce one record pilot. So that record, I could not bring pilot. So I may be granted some time pilot. Maybe it's on 24/7, 22 pilot.
24/7.
Yes, madam.
Okay. 24/7.
That records has not come. That is recorded.
You are here. Yes.
Yes, madam.
I will. This is something like this. This is the Disturbing Council for the Education Department. Published that the record directed to be produced by this court by an earlier order of this court has not been received by him. So his request for the granted time till 24.
Yes, 24.
So estimate to listen to 24.
Okay, please, madam. Date to mention item 19, madam. In item 19, in the main verification, madam, the respondent has filed a regional yesterday, madam. I don't have copy, madam, yesterday, madam. So, then waiting for some time will be given to go for regional, madam. And it's 20 is linked.
19 and 20.
After 2 months, madam.
This also it is on.
Here in item 19, madam, I am told the matter, it is not matter.
In 20, we are for the petitioner, the cases are linked. In which item you would like to find result?
Madam, they have filed the result yesterday, madam.
In item number 19, but it will have a bearing in item number 20 also. Cases are linked.
That is the reason.
You can't be filing reasonable in two cases.
No, I am not filing.
Which is the reason you would like to file reasonable?
No, my lord, I am not filing, my lord. They have filed a reason yesterday. So
Okay.
I need
On the
some time.
prayer of the council letter for the police, this is of 2 weeks.
On the prayer of Mr. Rintu Shekhia, I'm not asking.
On the prayer of Mr. R. Secretary of the council, this is also 2 weeks.
Let's list out object.
I beg to mention item number 25 to 35.
Yes.
Due to the health problem of the council for the ambulance, it will not come and he requested me to go to adjourn the program. So, on 10 August, I am for the respondent.
Item number 4.
Yes.
2 weeks will be given for finding out will be in the agreement of the entire project.
What is the matter?
It's a very complicated.
I don't know what.
Yes, focusing down.
After 2 weeks.
Very good. I beg to mention item number 14. On behalf of M. But again, reading of the matter is out of decision.
Yes.
The letter been taken up on 17 of this week.
17.
Yes.
On 17.
Okay.
I think to mention item number 3.
Yes.
Living council is administration, so it will be listed after 2 weeks.
What is the matter?
I was going to inform you.
This is 2016 that you were. Yes.
Yes, I like to mention item number 40, madam. Yes, madam, and I read before this one, I may be finding the withdraw the measure. That's because I petitioned that promoted to vice minister.
You are good then?
He
The superior of the council of the petition on this section 6 to withdraw the statement. The petition is not dismissed from the
Your Lordship, I would like to mention item number 18. Item number 18.
18.
Nothing concerns of physical activity,
Yes.
which are listed after 3.
Item 18 after 4 weeks.
I'll make the motion, item number 6 and 7.
Item number 6 and 7.
6 and 7.
Yes.
Yes.
Living persons having a person.
No, I can hear it. You're not audible.
Oh, living persons having a person.
Yes. 6 and 7.
Yes, we have it released on madam, in this item, madam.
Which council has personal difficulty?
I think item number 6.
I can
Yes.
see Mr. T.T. Tara speaking in front of.
We are,
There is a lady council in item number 7.
Look, here we are challenging the legality and validity of the stone transfer units.
You are
Item number 6, I'm appearing. And item number, yes, 7 also will. So here, Mr. Lolen, yeah, had a fracture on his right limb. So he,
You are making mention on their role.
yes, sir.
Okay. When do you want?
We have to say 17 August.
17 August.
Yes.
17 August. 6 or 7.
my lord, there is a issue of the.
Interview order.
Yes. Stay on.
Roller is for petitioner and 7.
Yes, ma'am. It is item number 7.
Both the petition gives the interim order.
No, ma'am, no. In item number 7.
Interim motor pass in 2021 to 2021 will continue to the next day of justice.
Ma'am, Your Lordship, I'm making mention on behalf of MDO, item number 10. This matter may be passed over 4 in the Your Lordship, since the council, Mr. M. Nehol is having red head condition.
Okay, after the week.
Your Lordship, this is the criminal petition and petitioner has been convicted already, so he has instructed me to pass over this matter 4 in the.
Okay, first of all,
Highly obliged.
yes.
Can I file one red petition? Therefore, will be taken up as a state. Red petition. We have to transfer.
What is the urgency?
The petitioner has been transferred in place of, and his, in his case, the private respondent has been given a.
When was the order transfer issue?
For now, I don't have.
We'll take it up tomorrow. We'll take it up tomorrow. There's no urgency. If you have a case, even if the person they join, we can put you back. There's no urgency. We'll take it up tomorrow.
As far as my knowledge, last week he was transferred. He was.
So we take it up tomorrow. Item number 1.
Lordship,
Yes.
application is lordship, restoration of the title should dismissed by the unless civil just senior division passing.
Okay. I'll stop up. This is what the leader of the state responses will be. Item number 36. Yes.
Also, this item number 36 is, item number 12. Yes. So therefore, the item number 12, will be taken up. So here, we have challenging some other, there is another, the manufactured documents.
Who is counsel for canceling item of the
Council for the petitioner is Mr. Pandey in item number 12 for the petitioner, and there, I am for the respondent, private respondent.
will be appear to the
No, whether the effect, this is for the past time.
who is responsible?
But these two items will be later.
Okay, so
Let it be item close.
who is here?
Mr. Pandey was here.
Call in. Yes.
My precise case in item number 36 is there is a transfer of the minor. In pursuant to transfer of the minor, the claim of the petitioner is he has complied with the order passed by the minor, the competent authority by which he has been transferred to the new place of posting. By manufacturing certain documents, minor official records. Other than minor, there is no such record by which the petitioner has joined. So therefore, I specifically the annex the copy of the documents, the charge, certificate of charges. He has claimed that precisely may take your lordships to the annexure 1 of my item number 36, I am not. Yes, ma'am. This is the transfer of the mother issued by the competent authority, whereby the private respondent hearing has been transferred from the Alo PHC and water circle, water supply circle to the two Foster PHC and water supply circle Pangin. This is the transfer order.
Who is the private respondent?
Private respondent is the matter the petitioner in item number 2012, Mr. Tuba Ang.
Okay. Yes, yes.
Thereafter, matter this has not been matter complied with. This has never been executed. This has never been matter complied with.
So this overall challenge this transfer order.
No, madam. Subsequent order, madam, annexure 2, page number 24, is the madam another order by partial modifications of the earlier transfer order issued by the madam competent authority on 30th, madam. By which madam I am brought a petition, madam, at serial number 4. Item number 2, madam, the annexure 2, page number 24, madam. Altogether, 3 officers the 4 officers is been sought to be transferred. But I am at serial number 4. And my SE sanitation estate coordinator SMBMG 2 SE Alo Banner PhD circle madam. Vice private respondent number 4. Madam, exactly this has been impugned by the madam private respondent number 4 in the petition number 278, item number 12.
Yes.
But thereafter, this writ petition has been filed. Madam, I have annexed a copy of the writ petition filed by the madam the petitioner in item number 12. Annexure 3 is the madam the copy of the petition along with the annexures. But specifically, at paragraph, madam, may I take your lordships to the paragraph 5 of this internet page is page number 38. Very much. Then the petitioner claims to state that as per the petitioner, as the petitioner being assigned to hold the BAG and water circle, Pangin while serving AC, PHG and WH circle Alo Banner by order dated 27/4/2023 as additions to his normal service and for handling and taking of the AC, PHG and WH
So,
circle.
can you represent the respondent in the same petition?
No, I have not been started copy. I will have to respond.
Then you should notice in this case.
Yes, I will have.
What we are exactly training for is for initiation of the appropriate proceeding is this some documents manufactured, they are committed the transiting manner. So therefore,
If at all, I have no instructions as of now, I don't even have a book. If at all there is a further event,
But before any order is passed, initiate criminal proceeding against the respondent. Respondent will have to be heard.
therefore,
But he said he has no instruction to appear in this case.
no, I do not.
so therefore, I'm friends of my first taken up the actual bill
Well,
case.
And how, my lord, this is something totally different. I don't even have a copy. When is the transfer matter?
Transfer measure. This is whether the outcome of the transfer.
They also take it, we can listen to them.
Yes, ma'am.
So which one you want, which one you want? This
Yes,
one?
in this case, madam,
In item 36, today at best, the court can issue notice.
madam.
Can we issue notice?
Yes.
Issue notice. Reserve for it. Who address them? Are you agree?
Yes, ma'am.
For 1, 2,
1, 2,
3.
1, 2, 3. And AAG.
Yes, ma'am.
For 1, 2, and 3. Steps by both this within a week. To respond to number 4. This is for the point. Yes. I can tell.
2 weeks.
2 weeks. Okay, 2 weeks. Yes, I can tell.
I think, well, my lord, I received a copy of the affidavit filed by the stay only yesterday. I need some time to respond. My lord, in item 12, there is already a stay order operating. In fact, the petitioner and the private respondent, petitioner and the private respondent number 4, they are the beneficiaries of the stay order. Yes, but so here, the issue is very similar.
That's the one. Order is a modification order.
Modification order.
When was due,
Yes.
where you had been sent to SC sanitation instead of allow. And for the first time, this cutoffs
Yes.
has been
Yes.
also transferred in that place.
Yes.
Uh,
In place of the private respondent number 4.
So you want to get allowed? Is it?
No, I'm fine.
No, sorry, funny.
Yes.
And he has been considered allowed, not
Yes.
funny.
Not fine.
Yes, what do you say?
Here, my lord, I just praying for some, in any case now he has raised this issue. This has to be hard together, my lord. My lord, if that issue. There is a hearing on item 36 that, yes. How can I respond to item 36 at this moment, my lord? Because the modification order, it was passed prior to that effect, giving effect to that transfer order. That who I am saying that is not the case. That is why I need to respond.
Any order you want, any modification of the entry for the first item, order in this case you want? No.
Yes, my lord, exactly, my lord.
Then there will be final application for that.
My lord, we have already, my lord, the affidavit has been already filed with respect to my lord, private respondent number 5, my lord. Wherein, my lord, we have categorically stated that, my lord, we have already joined. My lord, we are.
That was my lord, placed even at the time of the motion hearing, my lord. Even thereafter, let me finish. Thereafter, my lord, considering the manner in which the modification was done, this was the report was pleased to stay, my lord. They are the caveat, my lord.
Okay, once this modification of this 12th order has been listed, in so far as you are concerned, or the entire order has been?
No, the three of us.
In respect to us, my lord.
Because he goes in place of respondent number 4.
Are you
This can happen.
agreed by the entry order pass?
My lord.
Then why?
My lord, on the last occasion, my lord, on the last occasion, when the matter was listed for motion, on the motion, my lord. On that, my lord, the very thing, my lord, this honorable court was of the opinion that, my lord, the record has to be called for. And the record has been called for, my lord, on the last occasion. And that was for this, before this honorable court also, my lord. But after the, my lord,
What I will read is instant transfer letter, it involves just a simple issue, modification of the transfer order without any reason.
This has been very unfair, my lord. They served a copy yesterday to me. The ground that my learned friend is urging in the repetition, it is Act 36. They have not even taken that plea. Now, how can this be disposed of in this manner, my lord? The government has not taken that plea, there is a forgery.
No, I will not harp on this.
In any case, my lord, they have said what I have gone through is,
You have also got agreed.
yesterday,
Let us say the case.
yes,
If necessary, we'll give you a time to.
my lord, I need to respond to the affidavit, my lord. They just, in fact, factually, they have disputed, that is why I need to respond. I'm praying for long time. my lord.
What is there to be responded by this?
They have said, what I have understood is, they have said that the earlier transfer was not even given effect. That is what they are saying, but the record does not reveal so. Now, as far as the other thing is not reaching, that is forced now. I will respond to that.
No, earlier transfer order has been given effective.
No. The earlier transfer order. The earlier was in which I had taken charge of Angin. Your lordship kindly come to page 22.
Yes.
this is exactly not the transfer order, my lord.
This is not transfer. Let me start. I will finish that. This is not a transfer. I am aware of that. In view of the retirement of Sri Sasensas, SC PhD circle coming on attaining supervision on 30, and then the posting of delivered Sri Puba Anu is directed to checks over the charges of SC PhD coming circle in addition to his normal charges. This was the first order. I continued by additional charges given. Accordingly, my lord, I took over charge on 1st of May at the next phase. But my lord, before proceeding further, my lord, I am again submitting, my lord. I need to respond to the affidavit of the government man, not the private respondent. I am not required to. Because they have said that this order was not even given effect. They have transferred me as if I was in my lord. So by this order, I take charge. Additional charge. From Tamu Vidaka, who was the superintendent.
Additional charge of what?
Pangin sir. Then at the next page, I issue the circular first of May that I have taken charge. Page 24.
You are the superintendent engineer.
Yes,
All then is PhD and WS also.
yes.
What is WS?
What is it? Public Engineering University.
Then you want to get it? Pangin.
Pangin.
And what was the reason to modification?
That is why I am before also there is absolutely no reason. There is nothing. But then you also will see there is this thing they are talking about page 26, man. This is a transfer order, 30th of May.
Yes.
In the interest of public service, the government of Madhya Pradesh is pleased to order transfer posting of undermason to the officers. By this method, I was regularly transferred. Earlier, I was in additional charge. Now, my prime serial number 3 from Argo Bene to PhD Shardul Pangin.
Additional charge since when?
Additional charge is 30th of May. 27th April. 1st of May, I take charge.
What is the reason?
In fact,
This is what I'm trying to point out, madam. This 30th order they say was not even given effect to. That is why I need to respond. Because consequent to this, I have taken charge as page 27, which I believe is the document they are saying it is forced, madam. This is the document I believe. They are saying that I have forced.
Annexure to page 24.
Yes.
Page 23, madam.
Of your evidence.
No, madam, of the petition, madam. At page 22, madam, is the additional charge, madam. This is of 27th of April.
Right.
At Pangin. Then, at page 23 is the heading and clicking transfer certificate of the outgoing retired SC. Then, page 24 is the assuming of charge. These are all the additional charges. Additional charge while the petitioner was at NN, he took over additional charge at Pangin. This is on 1st of May. Then at page 26 is the transfer order. 30th of May. Now, 30th of May, the petitioner was regularly transferred to Pangin from there. That's serial number 3. Now, serial number 1 and 2, they also, serial number 2 was to take charge of petitioner from the Teju to Chennai. That is the primary respondent, number 4. All this, the primary respondent number 4 also did not take charge. Prior to taking of charge, the government decided to retain the petitioner at Benin and post the primary respondent number 4 at Pangin. As per the reference.
Since these, in fact, in our affidavit, it is just silent on that. Why? But in fact, I'm told that this was a request.
This is after 2 weeks, in which petitioner may file reply to the congregation state. Okay.
Has to be right.
He said that there is no answer to why. Well, here,
Therefore, on the last
No,
occasion,
but,
the recorder has called for bail.
Since it was, my submission is that since the
This is a transfer that it was filed on 19, they are not even allowing me to respond.
since government has the power to review their own orders, because it was not never given letter.
Whether they are factual, they have said that I did not take charge, I will have to remand that. Whether the injury protection might be extended. Okay.
Number 37.
May please. So item number 37 and 38 are same. The petitioner's grievances are same. What has happened in this case is that we will be pressing upon the IMU because there is a extreme urgency on our behalf for some kind of an interim relief. So what has happened in this case is that the item number 37, if my lord takes up item number 37,
yes.
There are two petitioners, my lord. The petitioners, my lord, as plaintiff, filed a suit for declaration as well as for permanent injunction. And my lord will kindly come to what was the suit from my lord, declaration and permanent injunction. My lord comes to page 34. Page 34 of the
54.
34, my lord, 34. Page 34. My
Yes.
lord, this is the prayer in the plain, and my lord will kindly see what was
This way,
this is the suit. Yes, the suit. Suit for declaration as well as for permanent injunction.
I by you.
Filed by you. Filed by me.
Before which law?
Before my lord, civil judge junior division, my lord, at UPM. And my lord, what was the prayer, my lord? Kindly see. A, my lord, may I read, my lord? A degree in favor of plaintiff and against the defendant declaring that they are carrying out illegal boundary one construction of the institute by leaving 10 meters from the central line of any so and so. And my lord will kindly see a degree in favor of plaintiff against the defendant declaring that intending boundary wall construction from the northern side of schedule A and B and amounts to encroachment of the plaintiff schedule land at page 35. And a degree of permanent injunction. But when this suit was moved, along with the suit, we had filed one misapplication that in this case, this is title suit number 4. In title suit number 4, the misapplication was registered as Miss J71. And in that misapplication, we had we had prayed for grant of an interim ex parte temporary injunction by waiving of the notice in favor of the opposite parties before my lord. And temporary injunction was for stopping them from carrying out their construction and or status quo. And my lord, by order dated 16/3, my lord, when this suit was moved along with the MISJ application, in the MISJ application, my lord, was by 16/3, my lord, interim ex parte injunction order was granted in our favor. After my lord, the status quo was granted. Status quo was granted because of which construction stopped. And my lord, by order dated 27/6/2023, my lord, the status quo order was vacated. Only ground for vacating the status quo order was that of the learned trial court was that on the basis of public interest, learned trial court was considered the interests of the public, but has failed to consider the private interests or the interest of the individual. But what has happened?
if I may give my lord a little bit facts of regarding the case, my lord.
Which is the impute order?
Yes, my lord. Impugn order, my lord will find, because my lord, so initially it was against the my lord at page 794, my lord. Page 94.
94.
Because against that misapplication, my lord, we find misappeal, my lord, under order 43 rule 1R. And the misappeal also, my lord, the learned appellate court was of the view, because of the public interest, again, my lord, we were denied in the status quo order, my lord. And my lord will kindly come to page 95, my lord. Page 95.
Yes.
Page 95, my lord, will kindly see at the second last paragraph, my lord. Heard the respondent being nourished a public institution which is funded by the central government, and the 8 northeastern states being its beneficiary by students from all over the any region pursue education. If allowed to stand without a wall, the security of the student is at stake, and stopping the construction of the wall will cause undue hardship to defendant. Therefore, in public interest, I am not inclined to pass any ex parte and interim ex parte temporary injunction order, and for proper education, I am inclined to conduct high-party hearing in instant application. My lord, as we speak, my lord, because ad interim ex parte injunction was not granted, because we had prayed for waiving of the notice to opposite party. But when we moved this honorable court under 227, my lord, we were told that we have to serve copy. So our misapplication is also for waiving of the notice against the opposite party, because there is an extreme agency. And under order 39, my lord is aware, under order 39 rule 3, notice can be waived if there is an extreme agency, my lord. And my lord, as we speak, my lord, the construction is going on, my lord. 80% of the construction work is over. And if the status quo order is not granted, my lord, we will be blocked from coming out from that land, my lord. Our ingress and egress will be stopped. What has happened, my lord, regarding the facts, my lord? The petitioners were granted, my lord, were allotted, my lord, 2 plots of land, my lord. Petitioner 1 was allotted, my lord, 30 meters square meter, my lord, and petitioner number 2 was also 30 square meter. If my lord comes to page 39, my lord, for a moment, my lord. Just the brief facts of the case, my lord. Page 39, my lord. Page 39, my lord will kindly see annexure to page 39, my lord. This is the order dated of 19 March 2002, my lord. And petitioners along with my lord 28 others, although the list is of 31, if my lord kindly sees at page 40, my lord. Petitioner number 1 is my lord, at serial list number 1, my lord. At page 40, if my lord kindly comes to at page 14.
Yes.
Page 40, my lord, serial number 1 is the petitioner 1 before this honorable court. And serial number 17, page 40, my lord, serial number 1. Name of the allottee, my lord will kindly see. Area is 300 square meter. Location so and so. Purpose commercial. At serial number 1, my lord. Page 40, my lord. Serial number 1, my lord will kindly see. And petition number 2 is serial number 17, my lord. Serial number 17. And in WPC, my lord, in the another CRP before we listed before, my lord, she is at serial number 16.
Where is this order passed on order dated 27/6?
Yes, my lord will kindly. Yes, my lord. My lord will kindly.
Missed 71.
At page 87, my lord. Page 87.
That is where the real division.
Yes, really.
Where is 70? Nothing will happen.
No, my lord, the construction will over, my lord. Only as of now also, my lord, the wall construction is going on, my lord. We are blocked from going outside also. We are blocked from going inside also, my lord.
If the wall will not broken, we will the titles.
My lord, that would be putting lots of things.
Will they complete the construction by 17?
Yes, my lord, they will complete, my lord. They are about 85-90% is over, my lord. I have personally seen, my lord, yesterday, my lord.
Personally?
Yes, my lord, because he is on the way, my lord, that is why. And my lord, 9-3, my lord, and 16-3, my lord, both the petitioners were granted status quo order without any rhyme or reason only on the ground of public interest. Junior division has vacated the status quo order and we moved before the London Appellate Court by way of misappeal in the misappeal also we were not granted the injunction status quo order. We are only praying before this honorable court for only status quo because so that and the suit land has to be preserved, my lord. This is a well settled principle of law, my lord. They are changing the nature and character of the suit land, my lord. What would remain for me to contest the suit, my lord? The suit has literally become infructuous. And my lord will kindly come to my lord, page number 92. We are in possession of the land, my lord. Page number 92. Page number 92, paragraph 18.
This revision petition is directed against the order dated 27/6/2023 passed in this case number 71/2023 arising out of title suit number 04/2023 where Court of Chief Civil State Junior Division Electoral Complex with UTI. However, the application filed by the petitioner under order 39 rules 1 and 2, read in section 151 CPC, praying for restraining the opposite parties from their men, from agents and masons from carrying out illegal boundary wall construction of the institute by leaving 10 meters from the central line of NH 415. And more particularly from the northern side of the scheduled games during the pendency of the school, and also for changing the nature and character of student to the disclosure of children and to maintain the status over the children has been dismissed. Also put on balance is the order dated 29/6/2023 passed in this year, case number 11/23 in this application 01/2023 where stated the senior division of the Electoral Complex of UP. When declaring to pass and exported as the temporary injunction order in favor of the petition and against the opposite parties. Have been declared and fix the matter for hearing on 17/7/2023. Any other order you send?
No,
Sure. Have you received notice, Mr. Apong, of that I missed the 23?
This petition officer, last night at 11 PM, I've been started.
Senior Pen has been contesting in the lower court also. So it is not that he is not aware that these petitions are being filed. He has contested, he has contested.
I'm aware, but where was the records?
Since the prayer made by the petition is this revision petition is coming up for consideration by the Court of Civil Justice Division of 2023 in on 17/7/2023 in this declaration of 2023 in the second number 01/2023 filed by the petition are not inclined to entertain this declaration. So this revision petition is the claim made by the petitioner is fixed for consideration by the Court of Civil Justice Division of the County of India on 17/7/2020. The revision petition for the business. We have
Till then, Lord 17/7, at least the status quo will be granted.
It is on the Court of Civil Division. Certificate on the application filed by the petition.
Item number 38 also is same, Lord. Lord, may I bring, Lord?
Case
Number will change, Lord. Lord, may I bring, Lord, till 17/7, Lord, status quo will be granted, Lord. Otherwise, Lord, everything will over, Lord, by then, Lord. Lord, at least till 17/7, Lord, I will be protected till 17/7, Lord. On 17/7, Lord, appellate court will decide, Lord.
We can decide the case also.
Yes, sir.
It will preclude the civil division from deciding a case.
No, no, no. The order,
And this court is also in agreement with the reason given by the first appellate court.
President.
How can an institution remain without a wall?
Lord, my private rights, Lord, and what about, Lord?
Private right is under consideration.
No, my Lord, my private rights will, Lord, get over, my Lord, by 17/7, Lord. That is the, Lord, urgency, Lord. Otherwise, there is no urgency, Lord. Only, my Lord, till 17/7, my Lord, till 17/7.
Where are the order included in this case, so that the case number is changed?
Lord, order review, my Lord, will find at page 78.
73 is also not there.
Yes, my Lord, 73 it starts, my Lord.
73 is the first order. And
Second, my Lord, will find at page 78.
Yes, these are only two orders.
Yes, sir.
Same order. We change in the, yes.
At least till 77 million status quo should be granted.
What is this IA?
IA for million injunction million. For status quo.
In the order cost in, sorry, dividend with IA system is good.
My suit will get dismissed.
Which suit will get this?
The suit will become literally infructuous.
Suit we are not concerned. Suit will be decided by them.
Yes, my lord, but in the suit, my lord, the whole prayer will get infructuous, my lord, if status quo is not granted. If they construct a wall, my lord, my prayer in the suit is that they should be refrained from constructing the.
Your injunction, see, your injunction petition is coming up for consideration on 70. How far is 70?
It's by 17.
You may get an injunction also.
An interim ex parte was not granted. That is why we have moved before this honorable court for grant of an interim, my lord. And an interim before my lord also we are praying for an interim because there is an extreme urgency because the construction is going on in 1 footing. If the construction gets over,
Right, it is rightly going on. No institution can remain where they want.
we will be not be able to move out once the wall is complete. Then where from we will move out from that portion of this land?
This revision court cannot answer that. You ask that question at the appropriate forum. You are under 115.
Yes, no, 227. 227.
227 will not answer this question.
I appreciate it, but not our injunction prayer is there. Then, my lord, legality will be decided by the order of the legality of the order will be decided by my lord under 227. But we are also praying for that IA for a grant of an injunction. Because if my lord is not considered, will not consider our case, my lord, then my lord, we will be remedialess, my lord. Our rights will be jeopardized. Where to move, my lord? Because appellate court has denied us. So we have moved before this honorable court.
Appellate court is in session of the matter, sir.
But it has not granted us an interim ex parte injunction, my lord. It has denied ex parte and interim ex parte injunction. That is why we have moved before this honorable
We
court.
are also denied. Ex parte exam.
Then, my lord, I will leave it to the honorable.
Yeah, order has already been dictated.
Because status quo, if not granted, then school will become infrastructure afterwards. Construction is over, whole way over.
Number 39.
The issue involved in this case is the petitioner is challenging the influence narrative.
Okay, this is
In the meantime, I'm seeking an interim prayer also.
yes.
The interim prayer is no decision should be conducted in view of this impugn final seniority order.
DBC for
For honesty, they are going to regularize. Well, just allow me to narrate the fact. Well, 2008, on 3rd August 2008, I was appointed by the director.
contingency.
I am a contingency employee. So then,
Where is the rule for?
because there is a composite rule, I have to explain. It is annexed. Last. Page of items. Will come at page 34. This 19 September. Now this record. Okay. This is the route first. Then further amendment has been done at page 38. Any come to page 38. This type copy is at page 39. Relevant portion has been typed. Kindly come to serial number. In case sufficient number of unskilled contingency staff, auxiliary labor corps, 39 I'm reading. Yes, that's true. Yes. I'm reading the type of. In case sufficient number of unskilled contingency staff, the auxiliary labor corps,
casual laborers are not available within 15 years of continuous service, the selection committee may consider contingent staff auxiliary labor corps, casual labor with up to 12 years of continuous service. The candidate will process the requested educational qualification of matriculation, ITI, or equivalence has been retained in the terms of pays. Let me place properly so that may not be.
I understood the case.
No,
Yes,
yeah, no, just still not. Let me place this.
I am passing an order in favor of you. I am passing an order.
A page
Who you are asking?
Indian penalty pays 31.
Yes, 21.
31, 31.
31.
Yes.
You are at
Serial number straight.
and what is
Is at page 32 below.
final seniority?
Final seniority list below. It starts from page 31.
No, no. Final seniority.
Earlier,
Final seniority.
earlier seniority list is first 2018 26 below.
Yes, 26.
26.
They don't also final seniority list.
That was provisional. They were supposed to give the finality to that. Here I states at page 27 below. Here I states at serial number 1. And Manoj will see that column number 4, date of joining. I joined in 6/10/2008. Now the private respondent 3 joined on 2011 and the 4 joined on 2012. Now, thereafter, they again initiated, then thereafter work at page 29. I was placed as serial number 3. Meaning thereby they are not counting my 7 years of services. This cannot be possible, or nor it is permissible under law.
Yes, serial number 2 is interesting.
Serial number 2 is responded number 3.
Yes. Go ahead, Commissioner.
1 and 2.
Yes, what do you say?
What should come, kindly come to page number 8,
Yeah.
serial number 7. In this, my lordship,
Page number 8.
page number 8.
Yes.
Serial number 7, my lordship.
Page number 8, there is no serial number 7. Or paragraph number 7.
Paragraph number 7. Like, the petition, may I?
Yes.
The petitioner begs to state that an unsettling finalization of a provisional list 2018 that the Directorate of Economic and Statistics Government of Arunachal AP Itamala has issued the interim provisional seniority list dated 8/9/2011 21 of unskilled contingency state telling inter alia after a thorough examination of all the claims and objections received from staff members. They have received some claims, my lordship, and objections from the other staff. So the petitioner was placed in serial number 3rd.
You read para 8. This annexure 5 is our representation against the state. This is a statement of facts.
So let me take instructions, my lordship.
When is your first joining letter?
21, page 21.
I was appointed by the director. This is appointment 1. Page 21 is my appointment letter. Then page 22 is my joining letter. I copy is at page 23. 6 October 2018, I joined.
Of unskilled competencies for the establishment of director economics and social. 7 June 2022. Well, the petitioner has been the petitioner's date of joining as unskilled competency study stuff has been shown as 7/5/2012. And thereby raising the seniority position of the petitioner below the respondent number 3 and 4. Also, the conclusion of the petitioner is that the petitioner was appointed as unskilled competency unskilled claims to Shakira. But end of this 3rd September 2008, issued by the Director of Statistics, pursuant to which we had joined service on 6 October 2008. 6 October 2008.
Then I was posted back to Itanagar, directed on 25/4/2012.
The petitioner has also drawn the attention of the scope to the provisional seniority which dated 20 March 2018, in which the date of joining of the petitioner as unskilled competency was shown as 6/10/2008. Then we was placed senior to the corresponding number 3 and 4. According to the petitioner content, that the date of joining of the petition shown in the final seniority list dated 7/6/2023 is incorrect. We should look at reasonable reports as the shown for the grant of the 1 and 2. No problem with the What's the purpose of the petition? All the requested numbers we start during the course of the day. Steps to serve the numbers of motion is going to become very simple. Very the process within a week. Consideration of the consciousness is by the division of the heritage the response of directly not the act of the influence in the structure. 7, 6, 20, 23, 30. Item number 2.
This is organized for number 6. That's one of the sections wherever they are trying for radiation to some amount. That is really
Who for the petition? What is this matter? Pending since 2016.
Your last week, you were granted time, 5 days.
You got to 75 words.
If we are unable to contact the petitioner person, so you are not very good. Some time will be given. Or your ready council JG administration.
Yes.
Yes, they are seeking for the trial. This may be the last chance. Otherwise, my record is speaking. Since 26/7/2019, my lord.
What is the matter?
So far, the matter is cancelled, my lord, in connection with the border area development, my lord. Border area development, my lord. These 11 petitioners are contacted, and according to their claim is that excess amount has been deducted by the department. So, my lord, in this regard, my lord, this honorable court has sought from the original voucher. The payment has that alternating to the payment made.
Minister?
Tahu tadi.
Now, the council for the petition. 2 weeks for the time is granted for prior to the affidavit in the regard.
No further adjournment.
Proceed after the doctor 2 weeks. Number 3.
Due to other circumstances, my senior is cannot be today. I need the middle day after tomorrow.
What is the matter?
Challenging an order of the circle officer matter. Initially, what he did, it is not even an arbitration proceeding. He chose all these so-called Gamuras inside a civil dispute.
Who is the senior?
Mr. Xavier. Xavier.
When do you want?
Day after tomorrow.
Will this is after a week?
Well, it's finally day after tomorrow, but they have to shift time after time because of this.
Mister? Also, for which responding?
5.
5. Don't speak now. Give the case.
All right.
Number 5.
Here, my lord, the petitioners are not agreed by the action of the survey officer in not taking cognizance of the application filed by the petitioners under section 50 of the Land Settlement Records Act. There has been a long ongoing dispute, land dispute between these two villages, Manda Pudung and Dompo and Manda Pudung. The Lordship may kindly at page 45. I will not take a Lordship through all the documents, only 45. 45. Lecture.
Yes.
This is the minutes of meeting, my lord. Wherein, my lord, the issue was decided in favor of the respondent parties. Admitted. Thereafter, my lord, the petitioners being villagers, my lord, this is not even a judicial order, actually, it was a minutes of a meeting. They continued to agitate, my lord, before the deputy commissioner and This kept on going. Ultimately, since nothing was done, we approached the Honorable Court by filing WPC 333 of 2013, at page 107. Rossip kindly come to page 113. The requisition was dismissed by page 113. Yes. Paragraph 11 from what I- Yes, madam. By filing the present litigation, the petitioner is making an attempt to reopen the same issue, seeking a direction for carrying out the French boundary demarcation. From the Matheson report, it has been seen that the residents of Longpur village were well aware of the decision taken in the meeting held on 29/1/1990, the document I saw you wrote, and also about the sketch map drawn up by the authority. There is no dispute that even the corrected sketch map has been received by the villagers of Longpur village. The petitioner has neither challenged the minutes of the meeting nor the sketch map prepared by the authorities. If they please so, divorce any challenge made to the decision taken in a meeting held on such as that, the petitioner cannot be permitted to reopen the aforesaid issue by filing the present petition. The report on the grounds of which the issues sought to be reopened are also apparently based on several displayed questions of facts and cannot be gone into the present writ proceedings. For the reasons stated here, now I would have used the relief of the present cannot be granted. The present is therefore dismissed. However, my lord, notwithstanding the order passed by this court, it will be open to the petitioner to find appropriate representation for respondent number 2. For resolution of any dispute arising within the four corners of decision taken in a meeting dated 29/1/1990 and a sketch map drawn in respect thereof. Liberty is also granted to the petitioner to approach the civil court seeking such different relief as may be available to him under the law. So, though the petition was dismissed, my lord, this liberty was granted. Accordingly, my lord, this representation was filed at page 115 before the deputy commissioner. You know, what are the lordships? You know, lordship will kindly come to page 124.
Yes.
So, pursuant to this representation, in terms of the order of the put by the authority, the committee is hereby constituted with the members given below for demarcation of the boundary between Bandha and Longpur. This 2017. So, consequently, there are other orders also that page 125. In condition order that is suggested for settlement of the boundary dispute is reconstituted. Another provision at page 126. However, the matter stage as it is. So, thereafter at page 127, I don't know how this happened, but they came in the form of a PIL report is on it, of course. I'm sorry, this is this was only available at the point of time. This is the
Where is the petitioner?
here by the petition, 127. That's misconceived, madam. 127, lordship can find the part of the order. This was withdrawn. The PIL, my last paragraph. The PILs are accordingly dismissed with liberty given to the petitioner to approach the appropriate forum as per law. They are also granted. So accordingly, at page 128, we filed this application before the survey officer under section 15. This they have not taken into consideration, that is why we are before lordship.
What is 50? Section 50?
Section 50 of the Arunachal Pradesh Land Settlement Records Act.
Yeah.
Now, they have come up with an affidavit, my lord, stating the reasons why they have not taken cognizance, the government affidavit. 4 and 5. Yes, affidavit of question 4 and 5.
What did they say?
They have said at page 11, my lord. Paragraph 26. They say that the issue is pending before the committee, but it was constituted in terms of request. That is why they have not taken cognizance. If that be so, my lord, let the committee decide. This is the only thing they, this way, that way. They may also hold also the 1990 plus settle. This is the only thing I'm praying for.
Okay, the boundary is demarcated by committee. Which committee? Committee, not a statutory committee.
It's not a statutory committee, but the liberty was granted by this honorable courts who approached the honorable the deputy commissioner. We had committed positive. If your lordship was of the view earlier occasion also, this may not be. If your lordship felt that in terms of the earlier order by liberty, they approach the civil court also, we will do that.
I think that if
Because I am not here on merit, only on that part.
only option is to buy a super.
That liberty, if your lordship processes with the liberty in terms of the earlier order, so then law will take care, delay and
What is
everything.
the section 50?
Section 50 is whether demarcation of boundary, demarcation of boundary. I don't know if this was also, that is how they filed it, I was not there. Page 221 of the volume, sir. Volume, sir.
There is a
221. In the room. Boundaries and laws. The boundaries of villages, survey numbers, subdivisions and fields shall be fixed and all disputes relating thereto shall be determined by survey officers or by such other officers as may be appointed by the government for the purpose according to the rules made.
Who is the survey officer?
Survey officer is something where the deputy commissioner has to appoint members in terms of section 4H. They will have to appoint actually.
Section 4H.
H matter. The government or such officers as will be authorized by the government in this year may appoint the following classes of revenue officers, namely H is the survey action.
Who is the survey officer? Mr.
My lord, the district lordship is the DLR. They are assigned with this.
They are the survey officer.
Yes.
Survey. They are so posted that the district will know your land and his land.
Was it?
They are so, which you say that the survey officer, they have been authorized by this act to demarcate the boundaries.
There has to be some basis, lordship. There has to be some basis. Otherwise, lordship, these are the village lines, lordship, which does not come under the government notified area. So,
So how this officer will know that this much is your land, this much is his
that
land?
is our lordship. This, in this case also, lordship, since the matter has been decided by the committee, on the basis of that,
Which committee?
Not decided.
Constituted. But which committee? How those members of the committee will also know that this is the land of this village. This is the land of village B. So where did we pick up this act? This is not suitable for the.
yes, exactly, lordship. There has to be some basis, lordship. These survey officers, how they will identify that this much of land belongs to that place and this much of land belongs to that place. So there has to be some basis. It is silent, this act, lordship.
How they will identify and provided under the act of the rules?
It has not been provided.
It is simply impossible. Is not it?
Yes, it seems so. This act, lordship, seems to be incomplete in that regard at least.
Well, just I am representing private explorers. Well, kindly appreciate.
What is your prayer now?
In this situation, my prayer was, my lord, the direction to the survey officer.
This is impossible.
My lord, that's why, my lord, in fact, these petitioners were, my lord,
But the matter is resolved.
yes, wrongly advised at various points of time. My lord, the process petition will liberty to approach the appropriate forum, then we will approach, because earlier we granted liberty to approach the civil court also. The other civil court will decide everything. There will be questions of delay, whether any cause of action arises consequent to the minus of the meeting that in 1990. Everything will be decided.
You want disposal of this issue to give it a liberty to the to approach the appropriate courts, like it
That was given in the WPC treaty.
Well, I have some objection. I really appreciate the fact there is a dispute between the two villages, Badlapur and Latop. And the land in dispute involves some 3 centuries ago. And thereafter, much of the protracted meetings between the villages of the two villages were. Then in 1989 and 90, the matter was resolved and rest to leave. That is 1990. 90. So now, that re-petition 33 AP and subsequent PI, which my learned friend has read out, liberty was already granted. That's one aspect. And number 2, now, the issue has been settled at that relevant point of time, my lord will recall, when the judiciary was not separated from the executive. It is in the capacity of a district magistrate that 1990 order was rendered on the basis of my district affidavit in opposition at page 24, 27. Committee reports and judgment at 27 to 30.
Which judgment? 6, 7, 7.
Yes, all.
Page number?
36. 36 is the stage matter of. This is 91. 31. Yes. Now 31. 21, 9, 19. 29, 1, 19. Now, this is the decision which they have arrived. My lord, type copy is at page 32. I'll only indulge my lord to clause 3 of this minutes.
Yes, 31. Yes, 31.
Yeah, 32 minutes, technical page, type copy. So these are everything, that we did not go to. Only this clause 3 is important, Roman 3. A meeting was therefore fixed in my office on 29/1/90, in which the committee members, Extra Assistant Commissioner Dhiran, Circle Officer Kalatan, and EAC Land Records Combina, and Additional Deputy Commissioner Bhogla were also invited. It was decided to accept the recommendation of the committee broadly with some minor adjustments. The boundary line between the two villages is the ridge starting from Mondupa and going upwards and passing through the Chongmasing and Pange Milan grazing land. From so-and-so line has been drawn to the joint the top ridge, the last point of Nukuru grazing land. The straight line will be demarcated by affixing boundary pillars. From Nukuru grazing point, the boundary stretches towards the west along the top ridge and reaches up to Serpukwa. A sketch map has been proposed indicating boundaries between Domko and Madlapuram village in red lines. The area under Domko village in the sketch map has been shown in the blue color. Now, all those things has been decided. Now, this decision, my lord, will come at page 34 is relevant. Roman 11. Now, these are the fines which they have given and paid everything. This is passed, my lord, you see at page 35. That is passed by the Deputy Commissioner. Yes, page 35. This order has been passed by Deputy Commissioner. Now, 2000, the AP Land Record and Settlement Act 2000. This act is enacted in 2000. The rules was framed in 2012. Now, my lord, the question of limitation comes. And law will never have any retrospective effect. It is a well-settled principle of. So therefore, filing this writ petition by invoking, what is that? Itself is not mentionable. 226. And now, in these two particular orders by this honorable court, even in the writ petition number 33 AP 2016, frankly, you are trying to reopen the case. Even having said so, Lord, the honorable court had given a liberty to them to approach the civil court. And thereafter, Lord, a civil, they filed one suit application before the learned court below, and that is withdrawn. No.
That is different.
That is the other side. Sorry, Lord. I'm sorry. Then, Lord, now the question is the present writ petition is mentionable? Is the present writ petition under 226 is mentioned? To my understanding, respectfully talk. The decision which has been already settled in 1990, 29/1/1990, and after a lapse of so many years, 30-something years, and if we see by the law of limitation, entry 64 goes out.
Okay, the government has said that, what is that? The record officer.
They have said that they have not taken cognizance because of this committee they have put it.
And for brevity and clarity, let us read that order passed in writ petition number 33. Double 223. It's there in the writ petition itself. In the government affidavit might not be taken up.
And it is in the writ petition 107.
107.
Some order has been passed. Record officer.
He did not take cognizance, that is why. Consequent to the PIL, since the liberty was granted, that application was filed under section 15. They just did not accept it. Ultimately, in the affidavit, they have said we have not taken cognizance because the issue is pending before a committee constituted by the defendants. That is the reason. Regarding the maintainability of the evidence.
Well, we'll come to page 108. The brief fact of the case. And this is a law enacted in 2000. 10 years down the below, much further has gone. And then the petitioners wake up from the slumber sleep and then approach this court that my right has been violated by these means, that means successfully waiving the right law.
How can we dispose it?
And
Because in the stand taken by the government. No direction can be given. They have expressed.
Yes.
So we leave it to you.
Yes.
This petition has been filed.
Page 25 method. Praying for taking cognizance that take on record application filed by the petition. Section 3.
Right? Seeking the direction to the respondent authorities. To take cognizance of the application filed by the petitioners under section 50 of the Arunachal Service Land Settlement and Local Review of the Arunachal Service Land Settlement and Record Rules 2012. And act upon it to exercise of its powers and put under the provisions of the Arunachal Service. Section 50 of the FPL provides for determination of village boundaries. Which reads as under 50. The boundaries of villages cover survey numbers, subdivisions, and field celebrities, and all districts relating thereto shall be determined by survey officers or by such other officers as may be appropriate for the government of the province, in accordance with the rules made in this matter. The petitioner appears to have filed an application under section appears to have filed an application under section 50 of the Arunachal Service, that is 82 of the Arunachal Rules 2012. Right.
This was in the year 2020.
Sometime in the year 2020. The next 2020. The instant respondents and filed counter affidavit where it has been stated that they are also of the district.
Correct.
They are of the district is the.
No, they have not filed that. They have only said that this subjudice list, they have used the word subjudice.
In paragraph 27, you have said that the matter is.
No, Lordship is asking in terms of section.
No,
I have filed affidavit.
they have no sense.
You mean who?
Lordship, I am for. Yes, sir.
Well, madam, if I may correctly understood, the question that has fallen from Lordship is that who is the survey officer? Yes, that is defined under section 4H. And in the, yes,
They have not filed it.
they have not filed the affidavit, and DRSO is the survey officer in the district.
Okay.
May I clarify this? There are some districts where ASSR has been posted and they are looking after all these matters.
Also is not there.
Yes, where they are also is not posted. The present situation in the state is like just for clarification also, although they have nothing right party.
Also, my kindly, there was government's affidavit questions the second time.
We are referring to the document at page 26 of the report.
Respondent number 3, huh?
4 and 5. Deputy Commissioner and the DLRSO.
4 and 5.
Yes.
Have filed counter affidavit. Where it has been listed that the survey officer, we'll say survey officer. Survey officer has not taken cognizance of the application for the on the ground.
Whether dispute is pending before the committee.
Also, we have not said so. Also, may kindly come to my page 11.
Okay, this.
Page 11, 27. What we have said is that the matter is pending, submitted before the committee headed by the ADC.
That is what I was pointing out.
What is that?
Paragraph 26.
26, 27. Also, may kindly.
Paragraph 26 or 27.
Yes, sir.
It starts from further. The land dispute between Nompo Village and Bandapuri is pending before the committee, headed by the additional deputy commissioner Dira as chairman, and 800 members as per order dated 13 April 2018. The document is at page 126.
Paragraph 26.
7 lines from the bottom. Starts from further the land dispute.
Committee headed by additional deputy commissioner
Dira.
Dira as its chairman. And 8 other members as per order dated 13 April 2018. What is the starting at 2018?
126 of the information. By the
They not the next step. 126.
This is the last order, that's why they have been.
But this cannot be the subsequent reason for not taking cognizance. Survey officer at least is a statutory authority. This is not a statutory authority.
Also, we are not saying that we are not taking cognizance.
Then you might take cognizance.
We have only said that it's
It is not a government land.
government land.
It is not a government land. In view of that, we are not taking cognizance of it.
Section 50 says determination to village boundaries.
Yes.
Who is talking about the government land? According to the Act, the survey officer has to demarcate, determine the village boundaries. Huh?
Now the question is, if section.
What the court is saying, see, survey officer is incapable of doing so. Huh? You are saying this method, this is telling for the committee. This committee has no. This is there's no legislation.
Even this, on the face of this order itself, is a very fair sign. This order itself is not sustainable. Another deputy commissioner is trying to review the decision already passed by another deputy commissioner.
We are not on that.
So this order is just for clarity. And now, my lord, as far as section 50, if strict interpretation is there, now can this section 50 have a retrospective effect? The question comes here.
Will come after 5 minutes.
Yes.
Apart from that, also, there was an inspection by the committee. During this inspection report is also there.
The inspection report.
Yes, that's
Where the
on
inspection
7/6/2011.
They start before the order pass by the law.
That's true. In this inspection, there was representative from both the villages where they are presented.
survey officer will do to demarcate the boundaries of these two villages? Have you thought about it?
Yes, Council. That's why actually committee was constituted.
Your land settlement record is like AFR. Another AFR. Huh? The government has to use, see, there is a lot of responsibility to rise. We can done it. He has the right to, that is why he has approached this court. The survey officer, the statutory, invested in the duty, is not taking compensation. It is first that order. Will he be able to demarcate the boundaries between these two persons? How he will proceed first of all? What did you propose initially, Mr. Mala? What did you propose initially?
Whether it would also involve the fields that the otherwise is statutory also. Rosin feels that he is not in that position. So I also feel that.
It will have a long term.
Yes, yes. Why don't we say
I think this one will be a.
I have understood.
I don't understand. I don't
But,
want to do that also. Yes.
That's why why don't we say that I have made a submission. In terms of the earlier orders, yes.
I think that will be the best.
Yes.
Appropriate for this.
Because even if I go for the civil court now, the civil court will take everything into account, delay everything.
At this stage, I can dismiss this case also, but at the same time, I would like to be here. I have the reasons to be here. And give a direction also to create a problem.
Correct, Your Honor. Close this with the liberty to the petitioner to approach appropriate forum
In terms of the earlier.
Three things.
First one was my lord. You wrote 105 days, 114, 13 and 14. Yes, we starts from 107, my lord. 107 in WPC 333 of 2013. Judgment date is 9/5/2017.
This is rendered by Lordship Suman Shah. And my lord, in the first aspect, as dismissed the writ petition, contention of the petitioner. And in the latter part, a small niche has been created in the form of liberty. That appears to be contradictory in nature. And this has not been challenged. So that liberty has been created.
Notice telling the order passed by the Supreme Court, the open to the petitioner to file appropriate representation for response.
You said that the also right to withdraw this with the liberty to express advocate for this.
Yes, without entering into the merit.
How is One, two, three. One, two, three. No, four. Four. And one, four, 3 and 5. Around 6, 2. So this is the petition. It means right to the audit, the coordinators, the state on the petition. Then settlement the
My lord, can record out to withdraw the praise for closing the matter with liberty.
This is very close. With the liberty granted to the petitioner to appropriate forum.
It was provided.
It was provided. That will be allowed in the 1970s, also down. It would treat it.
In my lord, PI number 41, read with PI number 1 of 2018. 2027. PI 1 2018.
Yes. Originated 25 to 2020. Pass PI number 1 April 2018.
Read with PI 41 of 2027.
Okay, with PI number 41 April 2027. The chair led by the also preparing for the respondent, this system, self close, we will go to the petitions, which are prepared for. Is provided by all of this course, with the 9,000 study ask the government to substitute this to every. Yes. Yes, sorry, what it is. The repetition is close to 1/7.
Okay, great.
Number 8.
Yes.
Now, we on behalf of Mr. S.K. Deoli, the leading counsel in this case, not present in the case. Matter is response to me.
Very good. What are we
Please
doing?
take this one to see. Please read me given.
Right.
Present of petition.
What is the matter about?
This is pertaining to appointment of private respondent as a regular LDC in DRDA. Yes, my lord, matter is also by 21. So, any fixed sorted.
There is still okay.
Your Honor, the order, appointment order has been set by this board.
There is still okay.
Yes. Yes.
Sure.
Yes.
The violation of this court's order. And it is still working.
But the petitioner is still good.
No, the respondent.
Respondent, my lord, respondent, since after stay of the appointment order, you know, I have no idea about the present status of the this respondent.
And the prayer is on behalf of Mr. S.K. Deoli. Also representing which respondent? Respondent number 7. This is Abdul.
Yeah, my lord, the matter is for on 17.
17. Yes, only available on 17.
No, I have some reservation. Which I will be out of session.
When will Mr. Deoli be available?
I'm not in,
After 2 weeks for it. After 2 weeks for it.
Your Honor, the issue here is very simple, Your Honor. Only the appointment order has been put to the challenge. Legality of that appointment order.
But this is in the last occasion, yes, of temporary arrangement.
No, temporary arrangement, but then temporary, but then
Petitioner is a wage-based employee. And this private respondent is a salaried person. So there's a difference. They have a different salary. Otherwise, he is getting at least 13,000 per month, and she is getting at least 18,000 per month. There's a difference in salary also. There cannot be a seniority between the petitioner and the private respondent. And there is no recruitment rule for LDC also.
that's why my lord, there is no recruitment rule. Then how this?
But when did you get the case?
That's because they are entering interim after 2 weeks.
My lord, 17.
Yes.
The matter has been dragged since.
And I have a case in the principal.
And it is on the part of the respondent only that this matter has can all this matter.
24. It is next version, next to next version.
All right. My lord, kindly make an observation in the next step. They will endeavor to dispose of the matter, the IE as well as the repetition.
That goes without saying, as far as this court is concerned. Today also I'm just to disclose that.
Last time also we came for disposal of the, they without informing us, without our consent, they took the time.
My lord, last week I was out of state.
And how can you give directions to act in a particular manner on the future court?
No, my lord, the same observation was made by this honorable court in the previous occasion.
Then we made to keep the lawyer community happy. See, how can you find the future court from acting freely?
I don't know, simple observation.
You also come across that on the next day, there is no examination. Have you come across that such order or not?
Yes.
On that day, particular day, there may be a genuine ground for examination.
Yes.
Isn't it?
Yes.
So there are various orders which will pass for other reasons.
All right.
We make an example of it, we don't say. We have met on behalf of Mr. S.K. Dury, counsel for the respondent number. This is from 24.
Okay.
Item number 9. Item number 9. Sign is again duty.
And this matter also may be adjourned.
What is this matter?
The legal counsel is Mr. J. G. So he is requested to seek that because he has filed affidavit in opposition. In fact, there is a, in fact, in the post title.
You are not there for Bangladesh.
Yes, sir.
Your phone, put your phone.
10 and 11. There is a mistake in the post title. So now there is two serial number one. Respondent number one. There is two respondent number one.
Anyway, your phone.
10 and 11. Yes, sir.
I am for 1, 2, and 3 also. Yeah, I have had. Yes.
One second. The house there is.
Who is that?
Whether or not it is correct.
I'll go 4, 5, 6 thousand.
One person, you are on record. Okay.
I'm on behalf of Mr. J. G.
Or council to actually. 10 and 11. 2 weeks. Other 2 weeks time is example to final company. This is after 2 weeks.
All right.
Item number 11.
This is a transfer matter, madam. This is also modification matter assigning without any reasons. Pleadings are completed or received.
You have for disposal.
Yes, Lord, for disposal. Lord.
Responded and disposal.
The only reason which my brother has, the petitioner has bring here is that while modifying the impugn transfer order in respect of the petitioner, no cogent reason has been assigned. That is the only grievance, Lord.
That is not so. I am the place I would like to press.
Okay, let us.
Yes.
Page 27, my lord.
It is the first transfer order.
Yes, sir. This is dated 15 November 2022. I am in serial number 7. It says in the remark column, the right hand side, I am posted from Government Higher Secondary School, Kanubari, as Deputy Director of School Education, Lebrata. He will join in the last part of April 2023. Now, by the same order, the private respondent, serial number 9, is also transferred. He was serving as GDSC SEPA as Principal Danikunia J0. By the same order. Then, my lord, since I was to join in the last part of April, and 28 was the last working day, on account of the incumbent going on superannuation, I was released on 19th April 2022. Release order space 29. The incumbent there was to superannuation. I was released. At page 30.
Which effect on 19/4.
Yes.
Okay. Okay, yes.
Page 30, I joined my lord, which is 20th of April. And the next page is the issue order. My lord has seen earlier transfer order, that means 9 incumbents were transferred. I am retained there at Jesus Kalubari. And the respondent number 5 was also transferred by the same order. Is my lord posted at my place. That's serial number 2. No reasons nothing. Then my lord, I filed this RTI applications. They have provided with me. It starts from page 35. They provided me with the file notice. Not only reasons, my lord, assigning without any reasons. It is in the behest of political functionaries. It starts from page 35. The relevant would be at page 42, my lord. Yes. Just after the line. You were not addressed to Honorable Chief Minister, rather received from Bokar Basar, MLA. Basar with request for transfer and posting of Sri Pobilongal at GDSC Basar in public interest. It is stated that the officer is very sincere and good administrator in education sector. Then the remark column they point out, officer, Sri Nyamor is SSP, is under order of transfer and posting at GDSC Basar by order number such and such. He points it out. Then my lord will kindly see at page 43. The second paragraph from the bottom. Serial number 6.
Yeah.
Serial number 6, Sri Pobilongal applied for DDSC Basar. However, Sri Nyamorina, Principal DHS Kanubari is under order of transfer as DDSC. Same thing, they point out again. Then my lord will have page 44.
Yes. Page 44.
Not 96. Authority may like to permit and take a decision for consideration serial number 1, 2, 3, 4, 5. Mention the serial, we are not considered. As regards serial number 6, Sri Nyamorina, one Nyamorina principal is already under order transfer as DDSC with MDC. We again pointed out. Then note 98. Here also. Again points out serial number 6, Nyamorina is already under transfer. Lebar district with MDC at page 30C. Then in the next page, my lord, they just put up the file and everything. Without any reason, and no 105 and page 46. Note 105. Sri Sasansa is transferred to DDSC Basar, Nyamorina, to continue at Kanubari.
Yes, it is Kanubari since when?
Since 2013.
When is the order? 4th September 2030 is the order at page 24. Chemistry number 8. I was headmaster vice principal at that point of time. My promotion was regularized by this document at page 26, 2014. I continue to be there. Serial number. Page number 26. He has been zero only for around 4 since November.
Yeah.
So when the humble submission panel, not only does the order does not replace any reason, the Honorable High Court legitimacy also the bylaw has also been circuitous when this transfer is in the order to interfere. Not only that it is arbitrary in the sense that it is on the basis of a human or by activity. That's it, nothing, there's no reason at all. Yes. Various decisions by this Honorable Court, I will not moderate notice by the division bench also. Recently, even just before the break, also similar order for the past steps. We will also pass.
Yes.
Madam, file our very, very question. Our contention begins from paragraph number 5. Our affidavit is a position matter. This is it's not being an official transferable matter. We have discretion to send his transfer and posting matter at any given point of time matter. You will see. In fact, this transfer modification has been consciously done matter. The record clearly reveals matter. It is not that he is being under transfer. It was not put to our record matter. That was very well brought into our record, but it was felt that the private respondent, who is a very experienced DDSC matter, and the Leparaka district is a very recently created district in infantile stage matter. That's why the department, the government felt it necessary matter to put the private respondent matter. And regarding his joining matter, in fact, we issued the order consciously because he was to join in the last part of the April matter. This gentleman petitioner was directed to join in the last part of the April, but he rushed with a devilish haste matter much before that. The last working day was in on 28 April matter. Then he ought to have take some break matter before joining there. He hastily joined there in the middle part, only 20 April matter. The decision was consciously taken matter in the interest of public service matter because this private respondent is a very experienced DDSC matter, and this petitioner has lesser experience matter as DDSC. Probably it is his first. It was his first posting matter. That's why the district being new matter, we consciously decided matter. Regarding this, you are not matter. You are not also matter. We cannot term it as behest matter, political behest, not exactly matter, because in this public representative matter, think for the betterment of the area matter. It is not that you will not carry something adverse to the petitioner, my lord. No. May I read the you will not? You will not says nothing bad about him, my lord. But you will not solicit the government, request the government. Then, in the interest of public service, my lord, this private respondent, being a very experienced DDSE, my lord, who has already served in various districts for many years together, my lord, the public representative has responsibly written this, and we have considered, of course, but it is not only the ground on which we have this. May I read, my lord? Page 49. Page 49, my lord, for the resolution, my lord. It is a matter of record. We admit, my lord, we receive it, my lord. As stated above, I am initiating this view or not regarding transfer and posting of Sri Puvilongi, who is presently posting as a principal at DK Government Higher Secondary School, Government Higher Secondary School, Hapoli 0, Leparada District as DDSE of Leparada District. Mr. Lombi is a very sincere and a good administration in education sector. Moreover, he had already served as Deputy Director of School Education DDSE in many districts under Arunachal Pradesh. Apart from the above, Visual Public of Leparada also, the Leparada District also apprises me for the transfer and posting of Sri Puvilongi as DDSE of Leparada District. Hence, I fervently request the Honorable Chief Minister, Arunachal Pradesh, to consider a transfer and posting of Sri Puvilongi, Principal, Hapoli 0 to Leparada District as DDSE, Leparada District of Public Interest. Your Lordship, it was written, my lord, not against actually the petitioner. This was independently written by the independently and responsibly written by the public representative, my lord, taking into account the welfare of the district, my lord. He has every right to do it, my lord. Apart from this, my lord, we also realize that, of course, the Leparada district in infantile stage, it will be expedient on our part to place someone who is really experienced and effective, my lord. That's why we put him there. And for such, my lord, for such positive notes, my lord, we cannot ascribe malice, my lord. My lord, for that, we will rely on this one judgment, my lord, reported in 2007, 2007, volume 8, SCC 150. Page 5, 6, 7, 8, my lord. Page or paragraph 5, my lord. Paragraph 5, 6, 7, 8, my lord. May I read, my lord? 5. In the state of Punjab versus Joginder Singh, that this court observed by page 2486, para 3 of the say area, we have heard Honorable Counsel for the parties. The court has timely and expressed its disapproval of the court below interfering with the order of transfer of public servant from one place to another. It is entirely for the employer to decide when, where, and at what point of time a public servant is transferred from his present posting. Ordinarily, the court has no jurisdiction to interfere with the order of transfer. The High Court grossly erred in quashing the order of transfer of the respondent from Hoshiarpur to Sanguru. The High Court was not justified in extending its jurisdiction under Article 226 of the Constitution of India in a matter where, on the face of it, no injustice was caused. It is also a matter, in fact, this situation would not have arisen had he joined at Leparada in time prescribed for his joining, means last part of September, this April. But he joined there prematurely. Your Lordship, para 6 in Avani Kanta, Roy versus State of Odisha, the court observed while SCC case 174 para 10. It is settled law that the transfer, which is an incident of service, is not to be interfered with by the court unless it is shown to be clearly arbitrary
or vitiated by malafide or infraction of any professed norm or principle governing the transfer. Para 7 again says, my lord, the scope of judicial review of transfer under Article 226 of the Constitution of India has been settled by the Supreme Court in Rajendra Roy versus Union of India, National Hydroelectric Power Corporation Limited. Sri Bhagavan, the State Bank of India versus Anjan Saibal. Following a process principle laid down by the Supreme Court, the Allahabad High Court in Vijaypal versus State of Uttar Pradesh and Ongarnath Tiwari versus Chief Engineer, Minor Irrigation Department, has held that the principle of law laid down in the aforesaid decision is that an order of transfer is a part of the service condition of an employee which should not be interfered with ordinarily by a court of law in exercise of its jurisdiction, discretionary jurisdiction under Article 226, unless the court finds that the either order is modified or the service rules prohibit such transfer, or that the authorities who issued the order were not competent to pass the order. Your Lordship, the order authority who has passed this is competent here, and there is no malafide ascribed, my lord, only the not my lord. He is saying only this not my lord. Note has also been written positively, not ascribing any adverse statement against the petitioner, my lord. Please come to para 8, my lord. May I read? Para 8. Learned counsel for the appellant submitted that the impure transfer order of the appellant from Muzaffarnagar to Mawana district, Merur, was made at the instance of an MLA. And here also MLA not initiated a you not my lord. On the other hand, it has been stated in the counter affidavit filed respondent number 1 and 2 that the appellant has been transferred due to the complaint against it. In our opinion, if the allegation of the appellant is correct, that he was transferred on the recommendation of the MLA, then by itself would not vitiate the transfer order. After all, it is the duty of the representative of people in the legislature to express the grievances of the people, and if there is any complaint against official listed, government is certainly within its jurisdiction to transfer such an employee. There can be no hard and fast rule that every transferred instance of an MP or MLA would be vitiated. It depends on the fact and circumstances of the individual case. In the present case, we see no infirmity in the impure transfer order. My lord, this entirely covers, my lord.
Yes.
My lord. Your Lordship. In 2001, 8 Supreme Court cases 574, my lord. Para 5, my lord. It clearly says, may I read para 5, my lord? On careful consideration of the submission of learned counsel on either side and the relevant rules to which our attention has been invited, we have reviewed that the High Court was not justified in interfering with the impure order of transfer. It is by now well settled and often reiterated by this court that no government servant or employee of the public undertaking has any legal right to be posted for one particular place, since transfer of a particular employee appointed to the class or category of transferable post from one place to another is not only an incident, but a condition of service necessary to in public interest and efficiency in the public administration. Unless the order of the transfer is found to be an outcome of modified exercise of power or is stated to be a violation of statutory provisions prohibiting any transfer, the courts or the tribunals cannot interfere with such order as a matter of routine, as though they are appellate authorities substituting their own decision for that of the management or against order passed in the interest of administrative decision. Proper trust to the departmental wing there. That's why we thought it was not expected that the petitioner would have joined there with his devilish haste, my lord. He joined there prior to the time prescribed for his joining, my lord. We directed him to join in the last part, my lord. Admittedly, last working day was on 28th April, my lord. 28th April.
But he joined here on 20, my lord. Much ahead of more than this, my lord, a week, my lord.
Yes.
That's why, my lord, we humbly celebrate on this, yeah, the department, my lord. This revision may be dismissed, my lord.
Yes. Who is this MLA?
MLA is Basar, my lord.
Local MLA.
My lord, local MLA.
Which party?
NPP. Oh, it's not their party. Which party? Which party? In politics, NPP.
NPP.
Yes.
Right.
So, but supplementing the government step, it is no more a res integra that transfer and posting is an incident of services. There are a catena of judgment by the Honorable Apex Court, by this court as well. The power of judicial review in exercise of power under Article 226 has been dealt in length by catena of judgments by the Honorable Apex Court as well as this Honorable Court. Being an incident of service, the subjective principle of law is that a government employee cannot claim as a matter of right. It is the employer who will decide where to post, where not to post. The government servant does not have that substantive fundamental right. Now, to start with my first theme of argument, the germination of the entire APU transfer and posting order is on the basis of the UO note initiated by the Honorable MLA of 29 Basar, Assembly Constituency, ST. Now, in paragraph 8, at page 11, we come to the repetition. Then, the note of the Honorable MLA has been referred to. Again, in paragraph 9, also the Honorable MLA's name has been referred to. Even at paragraph 10, page 2. Now, a legal friction comes up. Whether this present petition is maintainable without making the Honorable MLA as a party. Law is well settled, my lord. If an allegation is made against a person whom bona fide is alleged, must be made as a necessary party. On this count only, my lord, this petition needs to be dismissed for the hand of justice. Let me rely on this judgment, 2006 3CLT. It is by the division bench of our Honorable Court. I come straight to the paragraph 9. It is by Honorable Chief Justice, then Chief Justice B.S. Reddy and B.P. Kataki. 624. It is division bench of well, it's kindly come straight on the principle of transfer and posting only in this matter. Para 8 is relevant for the first instance. The next ground of challenge to the order of transfer is that the same was passed bona fide as it was because of the action taken by the respondent read petitioner against the wife of the adherent and also for recommending a transfer, as well as on the ground the same was passed at the behest of the minister of another department who has nothing to do with the education department. Now this is a question framed by Honorable Court, and then the law is here. No doubt, paranoid. An order of transfer can be interfered with the same is passed mala fide. The burden of establishing mala fide is very high on the person who elects it, and being it a very serious allegation against a person, it demands proof of a higher order of credibility and must be supported by the foundational facts. The person against whom the mala fide is alleged must also be impleaded as party so that he gets an opportunity to controvert such allegation. I will proceed further. Now, look, the Apex Code has also dealt the implement of a necessary and proper birth. It is by 2011. I'm saying on the best. No, that's why there are 60 inches.
Your conclusion is that
because the Germany of the issuance of the impune transfer order is by because of this, the UNO initiated by the Honorable Level. Therefore, no order can be passed behind his back unless he is not given a proper opportunity. Paragraph 16 of the read petition speaks for itself.
yes.
It says, page 17, that the petitioner humbly submits the action impugned. Action impugned includes starts from the UNO initiated by the Honorable Level. In the instant case, explicit, illegal, arbitrary, irrational, unfair, unreasonable, capricious, and the same impugned action is from with arbitrariness and mala fide on the face of the record. The face of the record, the word face of the record, includes the UNO of the Honorable Level. No person reasonably instructed in law would have resorted to such action as has been taken by the respondent authority, and the same is perverse. Well, this 2011 6 SSC JSC other case, paragraph 31 and 32. May I proceed, Bilal? Yeah, paragraph 31. Since the Honorable MLA has not been made as a party, no order can be passed behind his back. So therefore, paragraph 31 of this judgment says, no order can be passed behind the back of a person adversely affecting him. I'm posing for it. Mohammed Masood case law. It is well settled, which my brother has referred to. Elected members can initiate the UNO, and it will not vitiate the entire issuance of any transfer and posting. So here I am the elected representative of that constituency, and I have every right to initiate the UNO. I read, no order can be passed behind the back of a person adversely affecting him, and such an order if passed is liable to be ignored, being not binding on such a party as the same has been passed in violation of the principle of natural justice. The principle enshrined in the proviso is relating to the CPC order 1. So that I have to rely on the first part of this diagram. And even 32 also. This is a law on the first my first theme of argument is by not making the Honorable Emirate as a necessary party, no order in exercise of power under Article 226 of the Constitution of India, this court may have to relook on the exercise of the power. Now, can we come back here?
I have to learn it from the. जिसमें हम पढ़ते नहीं हो ऐसा लगा Yeah.
हाँ ठंडा हो गया
को दिया तो एक दूसरे को ट्रस्ट नहीं कर पाते
थोड़ा थोड़ा कम सुनेगा, उनका आवाज थोड़ा यहाँ तक कम आता है।
Sir. I asked him how long he said, sir, Tara is application. So whatever time the Tara takes, I will get sent to the work. Because it's going to be each of your submission. Problem arises when Tara enters into the philosophy. Tara goes into the jurisprudence in a way. The jurisprudence of the case. So that's it's always a pleasure.
I'll take another 7 minutes.
On implementing the Honorable MLA who has initiated the your note as a proper and necessary party, the read petition at the first instant must be dismissed. Now, my lord, the second limb of argument with the great magnanimity of my lord, if I'm allowed to initiate, is whether can an employed claim posting as a matter of right?
Okay, he cannot.
He
Third-
can.
Third,
Yes,
Ah.
he cannot. And my lord, to that aspect,
yes.
the issue is who should be transferred where?
It is within the domain of the authority.
Yes, my lord.
Yes.
And my lord will mark this, and that is 2022 Live Law SC 226. SL Abbas, my lord, paragraph 7 has been reiterated. So I rely on that particular judgment. I am placing it, my lord. Now, coming to the file noting, my lord. As my learned friend has referred vividly to the file noting to buttress his converse to an extent that there is an arbitrary and nullify the exercise of power by the employer while issuing the impugned transfer and posting order. Now, Milord, just I refer to this judgment, I am not placing it. Pimpi Chinwara, that was in that 2018, Milord, in that case, what had happened? The interpretation of the file noting. The file noting, Milord, the Apex Code has made it very loud and clear that file noting are the opinion of the individual officers. Therefore, simply finding that, my lord will kindly come this. My lord will kindly come to page 44 for a moment of the read petition.
Yes.
Now, it is by one undersecretary of the Education Department. Note number 96.
Yes.
Authority may like to peruse and take a decision for consideration of serial number 1, 2, 3, and 5 mentioned at note number 92. As regards serial number 6, 1 Sri Nyamo Rina principal is already under order of transfer to Leparada district as DDSE, which may be seen at page 35C. C means copy, Milord, and submitted. Now, it is only an opinion given by the undersecretary of the department. This gentleman is under order of transfer. My lord will mark the word under order of transfer. Now, under order of transfer does really mean that a legal and fundamental right has been accrued to the petitioner to claim as a matter of right to remain in a particular place of posting. The answer is no, my lord. For the reasons that, my lord, on the basis of a simple opinion expressed by an individual officer is not a decision, my lord. It is only expression of an opinion, my lord. Now kindly come to this particular page 46. It is the approval accorded by the Honorable Minister of Education, my lord. Has it, my lord?
Yes.
Page 46.
Yes.
Note number 105. Puvilombi Principal GHS 0 is transferred to decision DDSE Basar Sri Nyamo Rina Principal GHSS Kanubari to be continued at Kanubari GHS. Now, there is no nexus of that particular note. Milord is aware, the Council of Ministers is constituted under Article 164(1), which is headed by the Chief Minister. Now, under power of delegation, Milord, which rule is framed. In case of Arunachal Pradesh, Milord, it is 1989 rules of business allocations. Under that power, Milord, which they do exercises under Article 162 of the Constitution of India in the name of Governor, Milord. Therefore, the minister was within the justification, Milord, within a justification, with a rational thought process. Look, I am the head of in charge of the department. It is my ministry, and I know which officer is competent, where one should be posted.
You are not a government, you are a private respondent.
No.
Let us hear, Mr. Pang. You want to say
no,
anything in reply?
No, I want to conclude it. I concluded. So therefore, my lord,
You are arguing Jamo's case.
no, my lord, I'm coming to that because, my lord, it is always fair on our part also to share the knowledge through the deliberation of such kind of legal arguments, my lord. So I am trying to supplement it because when the counsel for the state has not come out with this proposition of argument.
No, he has,
On law.
he has made this argument.
No, therefore, my lord, I am
He
supplementing
has
it.
referred to Mohammed Masood also.
Muhammad Masood is one thing, my lord, that is a settled case.
I think Mohammed Masood is the case which will strike in your favor,
Root of the case,
if at all.
if at all.
It-
And I have
it
already
has-
read the mind of my lord, which way it is going to.
Ah.
Which way it is going to. I am aware of the consequences also. And I am going to fit into the scheme of my lord's mindset so that this case is decided today, whether this way or that way, my lord. Without malice, my lord. So, my lord, I am coming to that, as I said, my lord. So this particular decision has been taken. Now, the fundamentally, my lord, I may kindly be allowed to rely on this Kalyan Chandra Sarkar judgment. That is,
For what
not
proposition?
Tirtha's, my lord.
For what proposition?
Tirtha, 2007, 1 GLT 456 on the proposition that transfer and posting is a matter of policy by the employer.
But he is against the modification of the transfer order.
Correct. I'm not disputing that. The question is, was there any rational nexus in issuing the impugn modification order? So therefore, even if, my lord, the transfer order has been modified, then it remains the domain of the employer. My lord will kindly see Fundamental Rule 11, my lord. Fundamental Rule 11, it clearly says, whole time of a government employee is at the discretionary of the employer. How and where to deploy a particular officer is at the discretion of the master employer, because he is paid out of the public exchequer. Fundamental Rule, my lord, 14 itself also is a settled proposition. That, my lord, B.N. Joshi case, Silpi Bose case also. In fact, my lord, that Silpi Bose case is the one which has laid down that employee cannot claim transfer and posting as a matter of right. So this we have already dealt with. And Govardhan Lal case, my lord, 2004. So as I said, my lord, as I have submitted, that transfer and posting is an incidence of service. An employee, the moment he or she joins the public employment, if her post is transferable, my lord, then even if there is a violation of certain procedures also, that will not entail any fundamental right. My lord, lastly, I place one more authority, my lord, 2020, 3 SSC 404. On the same propositions, you cannot claim as a matter of right, but the Apex Court has dealt it. In such matter, the Reed Court, the High Court should slow in interfering the order of the transfer.
One authority of the Supreme Court is not enough.
It is enough, my lord, but my lord, what had happened was in this case, my lord, only one paragraph I will read, my lord. It says, when the Reed Court in exercise of such power was deprecated, my lord.
It's not the number of bullets which matters. It's the point where you hit.
No.
And the nature of bullet that matters.
Yes, my lord. So these are beautiful words for fallen down from my lords. And this we have to respect. As an officer of the court, my lord, as a matter of propriety between the bench and bar relationship, my lord, we are always duty bound to respect each other. So therefore, keeping in mind, my lord, kindly allow me to read this particular paragraph 4.
Transfer case and bail matters should not take more than 10 minutes for each of the counsel. And not more than 15 minutes for the court to dictate.
I'm finishing this paragraph and then one more judgment authored by my lord.
Yes.
When this similarly situated case, my lord. However, we are categorically of the view that the impugn order of the High Court interfering with the order of transfer was in excess of jurisdiction and an improper exercise of judicial power. We are constrained to observe that the impugn order dated has been passed in breach of settled principle and precedents which have constantly been enunciated and followed by this court. The manner in which judicial power has been exercised by the High Court to stall a lawful order of transfer is this waiting. We express our disapproval. That 2020, that
Yes.
I given the judgment. It is by His Lordship, Dr. D.Y. Chandrachud, who has rendered this judgment. Now, my lord, where is that? High Court order. Now, my lord, has taken very recently, my lord, in a division bench, my lord, that Vandana Nasi case, my lord, is aware. It's okay, we will not rely on. Where there was an stay order of the modification of the impugn transfer and posting order, that my lord has taken a view and my lord have interfered with the stay order granted by the learned single bench. And this matter went up to the Supreme Court. And finally, it has been decided. I have the copy, but I'll render. So that in this particular matter, I am relying on this Yade Nasi case, Education Department.
This matter is minor dictum, exactly same matter, similar nature. It was also of DDSC, Daporism minor. Now it is for the DDSC Basar minor.
Thank you, brother, for the supplementing. My lord, kindly come to page, internal page 4. The fact is same. My lord, that highlighted portion.
Yes.
Para 7 is quote, considering submissions made at the bar by the learned counsel for the petitioner, the Education Department as well as the respondent number 5, it appears from the note number 234 that against respondent number 5, the following observation is made in column 7 relating to brief reasons cited for seeking transfer, which read as follows: joint representation of your note from Honorable Emirates requesting for transfer and posting of the incumbent as current DDSC. The operator is going to retire soon. Unquote, dash page 8159 by C. From the footnote of the said note, it appears that the same was made on 17/10/2022 at 3:10 p.m. Therefore, it is presumed that when the transfer order dated 15/11/2022 was passed in respect of the representation made by respondent number 5, similar note is also made as note number 242, prepared on 9/11/2022 at 12:42 p.m. and as per note number 258 prepared on 16/11/2022 at 12:22 p.m. It is mentioned that as directed by the Honorable Minister of Education, file is resubmitted for onward submission to Honorable Minister. Further, at the note number 260 prepared on 19/11/2022 at 12:08 p.m., it is mentioned as follows: on request of all Honorable Ministers and MLAs of Upper Subansiri District, Srimati Yade Nasi, Principal, GHS, Ligu is posted as DDSC Upper Subansiri. Sir Proctor Rime, Principal, GHS, Namsai will remain as Principal in the same school. Now, what is the finding of the, my lord finding is at internal page, which one? Internal page 6, my lord. Then it's okay, I'll not refer to. Look, para 7 is also important at page 6. Page 6 bottom, kindly come.
Yes.
The political persons referred to by the learned single judge, as can be gathered from the finding of the facts recorded in paragraph number 7, which have been extracted here and above, we have noticed that political persons refers to are the departmental ministers and the minister and MLAs of Upper Subansiri district. This, my lord, that Mohammed Masood ratio, my lord, is referred to. Now, my lord have discussed. So therefore, and then my lord has vacated the interim order. This is the view of my lord. Now, my lord, what had happened? Pursuant to this judgment, the petitioner has went up to the Supreme Court, and Supreme Court has reverted, has finally remanded the matter back, my lord. And most probably, my lord, yes, my lord. So most probably they. Good, I can verify this. My lord, here what had happened was, Lordship Ete, in a very recent judgment, my lord, will you just afford me a moment? I take out. I'll give it. So yours, but what had happened is, it is not available with me, but this judgment has been rendered, interfered with the impugn transfer and posting order for not assigning any causal reason. And the matter was remanded back to the employer to take a fresh decision. So in this matter, in this instant case also, my lord, even if my lord interfere with for a justifiable reasons within the ambit of the law, then there is no hesitations, even by the state respondent or to me, my lord. So therefore, my lord, as the law is well settled, I'll not detain my lord further by making further arguments. My lord will only remember the legal principle that whether this court, in exercise of power under Article 226, can interfere with the policy decision of the government to post a particular officer in a particular manner and where to employ him and how to use the services. Graciously.
I would not have taken much time, but so much submission has been there. I will have to splice some of them.
Where is that?
Man, this division bench judgment your lordship had authored, my learned friend is referring to. Your lordship may kindly have page 7.
Yes.
Your lordship was of the view that the learned single judge has issued the impugned stay order on the basis of the notes of the MLA, whereas the pleaded case of the petitioner was that it was modified without any reason. Your lordship kindly have page 7, third paragraph. Viewed in that line, since the impugned order of stay by order dated has been passed by the learned single judge only on the basis of the notes made and circulated by the honorable minister and MLAs of the district concerned, who are of the view the respondent of the writ petition, though may have raised an issue to be examined and determined finally in the writ petition, but the case projected by the writ petitioner in the writ petition lacked stock privacy case for passing an interim order of stay of notification, much less the balance of income is repaired, which cannot be compensated to the writ petitioner. As has been discussed above, here in the writ petition, challenging the model, what requires to be determined is whether is the sufficiency and adequacy of the reasons for such modification, which could have been only determined after the pleadings have been exchanged by the parties. We are of the view that in the instant case, the learned single judge has committed error of law in the absence of respondent number 5, making out the so this was your lordship's view. This is can be determined only in the final stage, and that has now been, my lord, determined. And then, my lord, I don't know why this was placed, man. I will first respond to, my lord, the submission of my learned friend representing the department. What he has submitted is, because the respondent number 5 is a very, very efficient officer, that is why, considering that we have
posted in Basar, which is revealed from nowhere, madam. Nowhere. Neither does the order reflect that, neither does the file notings reflect it. The file noting simply reflects it is at the behest of the respondent or the note of the MLA. This exercise was undertaken. So this is an arbitrary exercise of power.
Yes.
That is the one. And the Muhammad Masood was relied upon. That was a case, my lord. There was a complaint of corruption against the petitioner. It was in that context the Honorable Supreme Court has held the duty of the public representative to address that to the authorities concerned. It was in that context. So that does not support their case. The Supreme Court says every you or not may not vitiate a transfer and posting order. That is it. Now, my lord, I'm reiterating again, there's no reasons nowhere that regard that it is because of his efficiency that he isn't posted. My lord, you recall, if that was the consideration, why, my lord, in the 15 November order, he was not directly posted there and I was posted there? My lord, is there various judgments of this Honorable Court regarding modifications? Should I rely, my lord?
Modification?
Regarding modification, there has to be reasons.
No, as for modification is concerned,
yes.
If they have the adequate and justified reasons,
yes,
they may modify.
Yes,
so the only issue which requires determination is that the modification of the order on the basis of the UO note put up by the local MLA was a sufficient and adequate reason. Was it adequate and justified
Exactly,
reason for modification?
So I will not bother also with the judgments. There are various judgments. And regarding my learned friend about making the MLA a party, I just like to rely upon a division bench judgment. 2009 2 GLT.
No, making a party is your prerogative.
No, what I am submitting is it's not a necessary party because I have no quarrel with my learned friend. In fact, my learned friend has submitted that no order, adverse order can be passed against somebody by not making a party. What adverse order will be passed against the MLA, my lord? The only my pleaded case is it is at his behest, my lord, this was passed.
What is this?
This is my lord division bench judgment regarding requirement of making party, the MLA.
No, making any of the authority a party by person or whatever it is.
It is
that
is not necessary.
Required only if you LS Malafide.
Yes.
So you are not eligible in Malafide.
That's it. There is no reasons assigned and there is no adequacy of reasons. It is only on the basis of the you are not, my lord, this has been done. And this, my lord.
What do you say on the right of the local MLA as a representative of the public to have his say?
He may have his say, my lord. There are various judgments over our court itself. Once a transfer order has been made.
So this can be one of the reasons.
Yes.
Which may be bona fide.
My lord,
which may be justified. We are not saying that it is absolutely justified and bona fide reasons, but they have some reasons.
But you have, Lordship has seen the file notings. They have nowhere they have applied their mind, my lord.
Unless the political executive have their officers of choice.
That is something else, my lord, your lordship cannot allow.
How they will be how they will be able to execute their policies.
I understand, my lord.
Correct. To that extent, they have the right. I'm not saying that
no,
yes. Here. What I'm saying is that this might not vitiate the modification order. They have some reasons, and we should, if they have some reasons which appears to be bona fide, we should not venture into whether it is justified or not justified.
But there is no reasons, my lord. I have annexed the file noting.
No reason. Everything comes on the reasons. Huh?
Because that's what, my lord. They will have to show it, my lord, by way of an affidavit or something. After it's a court of record, my lord. There is nothing on record. My learned friend has submitted. It is because of his efficiency he has posted there. From where is he submitting that, my lord? That is a submission. That is a step taken by the government, my lord. But there is nothing on record.
We must have a register of our choice. if the High Court has to implement its.
That is another thing. That is another thing. This is not about policy, my lord. He is an MLA for the. He is not an MLA for the education department. He cannot do that.
All right, Mr.
My lord, similar matters. In fact, same post, similar type of matters is to course have interfered. 2020 volume 3 also.
Which one?
2020 GLT 275. Yeah, various orders, various unreported judgments also I have brought in fact. I'm not bordering on those.
What is that?
That is similar.
See, that also must be, you can modify the transfer order issued earlier.
Yes. Only
for the reasons adequate.
Overwhelming.
That's
reason.
all.
The same.
So what is the
dicto case.
adequate? What is the adequate and justified reason?
That was exactly similar case. Man. They are also interference of the MLA and approval was granted. Exact.
Which one?
275. Paragraph 13.
Yes.
At page 280. Merit.
Yes.
When the authorities are required to modify the order of transfer for accommodating some officer, they are required to assign overwhelming public interest. In this case, no reason whatsoever is signed. In the respect of petition response number 5, the file support only contains the note of the concerned MLA to the Minister of Education, on which the Minister of Education has issued a direction to retain the response number 5 and to transfer the petitioner to Longding. Same case, man. There is no representation by respondent of in the file produced. Moreover, no one is disputing respondent was not a dedicated or decorated officer, but while transferring him by the order that the authorities are deemed to be aware of his activities and his decorations, yet the competent authorities had transferred him by assigning that the transfer was in public interest. It is expected that every officer posted in a particular place will work dedicatedly, but it does not mean that if one officer had initiated a particular program, the government had given him a personal responsibility to see that until his program concluded, such officers must be stationed at one place.
See, here the learned single judge may have gone little beyond his domain.
Maybe, my lord, but ultimately it was.
No one is disputing that the respondent was not a dedicated or decorated officer. This is not our domain.
Maybe, my lord, but the fact is they are also not of the MLA, and on that the minister has acted. That is the only thing.
That choice we have to leave it to them. Yeah.
My lord, my lord, may kindly record my submission that, my lord, there are several judgments of coordinate benches, my lord, similar facts and circumstances, where, my lord, modification order without assigning any region has been, my lord, interfered with. Unreported, reported various judgments.
Just without assigning any reason.
Yes.
Any
first judgment is 1997, madam.
That is by the single bench.
Yes.
Any by the Supreme Court and the.
Not by the Supreme Court. This is something, my lord, that is
by the division bench.
Division bench, not that I'm not aware of. 2001 is also by. This is also by single bench.
Single bench.
Single bench. 2020 is also single bench.
They may be right, but
In
they may have
fact,
exceeded also. Exceeded.
I have one authority or.
That is the Supreme Court judgment. This is suitability, sincerity.
Correct.
Is not within our domain.
That is another thing, my lord. My lord, in fact, but in that case, my lord will, my lord, record these citations, my lord.
If
Paragraph 8.
If there are judgments by the division bench of the Supreme Court, we may look into it.
Yes. Paragraph 8. Then 2001 also, my lord, page 67. Then, my lord, 2001 3 GLT, page 67. Here, the 1997 judgment has been referred to.
What is that Hibutama case?
My lord?
The mobile number.
5 and 6, I'm relying upon. Paragraph 5 and 6. 5, the 1997 case has been quoted, paragraph 8. Then 6, the principle laid down in both the two cases is that once transfer is made in public interest, subsequent orders cancelling or superseding must be supported with sufficient reasons. If any such order is passed in a cryptic manner without assigning any reasons, that would not seem to be done in public interest.
These are all prior to Muhammad Masood. After
Masood, my lord,
dimension will change.
Masood, my lord, in the humble service, my lord, record my submission. Masood was a case, my lord, where there was a allegation of corruption against it. That was pointed out to the authorities. It is in that context, my lord, that Masood judgment was passed, my lord. But 2020 is after Masood, my lord. And my lord, this is also after Masood, 2020. Binam Messar case. I am relying upon this. And this was passed on, my lord, 30th of, on last 30. This has been uniformly followed by this honorable court. Yeah.
Rajinder Singh and others versus State of UP.
And my lord is aware of this honorable Supreme Court judgment also. Senior officers cannot mortgage their conscience, my lord, just at the behest of, what is the public interest involved, my lord? Some MLA has given a note and the authorities will act upon that. That too, after, my lord, carrying out an exercise, wherein 9 incumbents were transferred.
High Court seriously erred in deciding as to whether respondent number 5 was a competent person to be posted at Ghaziabad for a sub-registrar. The exercise undertaken by the High Court did not fall within its domain and was rather uncalled for. The High Court entered into an arena which did not belong to it and thereby committed serious error of law. Competency of law.
But my lord, I am not calling upon your lordship to decide, my lord, whether they are competent to transfer somebody there or not. I am before lordship, my lord.
Suitability.
Yes. But here is a case, my lord. This honorable court has, my lord, consistently has not deviated from this. Once you pass a transfer order, you cannot, without assigning any reason, my lord, modify that. Since 1997, my lord.
The reason is the note of the MLA, isn't it?
Correct.
Yes. Reason is that they are not disputed.
Yes,
Whether this is sufficient or not. Okay, all right, well.
My lord.
The Pangu for petitioner. Jamu for 1 to 4.
1 to 4.
And Tara for 5. This writ petition is directed against the order dated 12 April 2023. Passed by the Commissioner Education Government of Arunachal Pradesh, right number says page 31. However, the petitioner has been retained as principal GHSS Kanuveri Longding District in modification of the earlier order of transfer and posting dated 15 November 2022, by which however the petitioner was transferred from the post of principal GHSS Kanuveri Longding District to as DDSC Leparada. DDSC, right in full from DDS Leparada District. The facts leading to filing of the present writ petition briefly stated as follows. The petitioner, who has been working as a principal GHSS Kanuveri since 2014. 2013 was transferred as DDSC Leparada by an order dated 15 November 2022, issued by the Commissioner of Education, Government Honorable Barnum Swanson at page 27, indicating that the petitioner will join in the last part of April 2023.
Yes, respondent also was transferred.
Post of by the said order of transfer dated 15 November 2022. The respondent number 4, who was working as a DDSC SEPA, East Coming District, was also transferred as principal Dani Kunya GHSS 0. According to the petitioner, pursuant to the aforesaid order of transfer date 15 November 2022, the petitioner was released by an order dated 19 April 2023, passed by the Deputy Commissioner Longding District by number at page 29, with effect from 19/4/2023, enabling him to join his new place of posting at Leparada District as DDSC Leparada. Pursuant thereto, the petitioner joined as DDSC Leparada by submitting on 20 April, isn't it? Yes. 20 April 2020 by submitting a joining report to the Deputy Commissioner Leparada District Basa. While the petitioner had joined as DDSC on 20th April 20, DDS Leparada 20th April 23, on the same day, the impugn order of transfer dated 20th April 2023 was issued by the Commissioner of Education, Government of Andhra Pradesh, whereby the petitioner has been retained as principal GHSS Kanuveri Longding District and the respondent number 4, who was by then working as what is DK? Okay, as principal Dani Kunya GHSS 0 has been posted as DDSC Basar, Leparada District. According to the petitioner, the impugn modification order dated 20th April 2023 has been issued by the Commissioner of Education Department on the after the same was on the basis of UO note. Dated 28 February 2023 by the MLA 29 Basar ST Assembly Constituency. As it on the basis of which was acted upon by the competent state authorities when the same was put up to it. Also, the petitioner accordingly, the petitioner therefore contends that the impugned modification, impugned order of impugned order dated 20 April 2023 issued in modification of the earlier transfer and posting order dated 15 November 2022 2022 What is the ground of your challenge, Mr. Karan? What is the ground of your challenge?
The first ground of challenge is that it has no reason has been assigned in the transfer or modification order.
No,
The
in so far as this EO note is concerned? In so far this EO note is concerned?
That is at the behest of the MLA without assigning any reasons. That's why arbitrary.
Therefore, what did I say? Cannot be sustained as the same has been issued at the behest of the MLA of 29 Basar ST Assembly Constituency. Apart from the impugned order dated without assigning any reason. The state respondents as the private respondents have filed their counter affidavit. Those counter affidavits.
Covered in 5 section 8, paragraph 5 section 8.
In the counter affidavit file, the fact that the impugned order dated 20th April 2023 was issued on the basis of the EO note dated 28th February 2023 by the MLA 29 Basar ST Assembly Constituency. Have not been disputed. Mr. Panging, honored counsel for the petitioner, assailing the order dated 20 April 2023, has submitted that once the petitioner has been transferred as DD transferred from GHSS Kanuveri Longding district and posted as DDSC Leparada district by an order dated 15 November 2022. The said order could not have been modified by the impugned order dated 20th April 2023 without assigning adequate and justified reasons for such modification. Also, he has further argued that the U note dated 28 February 2023 by the MLA 29 Basar ST Assembly Constituency which has been acted upon by the correspondent authorities in issuing the impugned order dated 20th April 2023 cannot be a reason adequate and justifiable for modification of the order of transfer and posting of the petitioner dated 15 November 2022 by the impugned order dated 20 April 2022. This is the substance of the argument.
Yes.
No reason, not justified. There's no reason, even if this is reason not justified. You want this decision to be cited?
Yes, sir.
Okay. In support of his contention, Mr. Just give you.
Yeah.
He has relied on following decisions rendered by this court also. Mr. Jammu Learned Standing Council for the Education Department has argued that the petitioner has been retained as principal GHSS Kanuveri and the respondent number 4 has been posted as DDSC Basar Leparada district by order dated 20 April 2023 in modification of the earlier order of transfer dated 15 November 2022. On the ground that the respondent number 4 has been found to be
More experience.
more experienced.
My paragraph, my reply paragraph number 12 will cover everything, madam.
Paragraph number
12 of my affidavit will cover everything, madam.
12.
12. My reply 12. I have 10 also. 10 and 12 maybe directly reproduce, my no issue. Paragraph 10 and 12. We admit, my lord, we received the U honor, but it was not the only ground, my lord. It covers everything, madam.
Paragraph
Paragraph
12,
My 12.
not 10.
10 is
Okay.
also important, not required,
Okay.
my lord. 12 will cover. Actually, it is the actual ground, madam.
He was found to be more experienced. Huh? More experience. And how did we begin? Is that good, huh? No, I can't hear you. No, only one. Huh? Okay, on the ground, the respondent was found to be more experienced. More experience in administration in district level, as he had already served as DDSC in district level for many years. Also, he has further argued that the UO note dated so and so by the so and so assembly constituency was also received by the government, but the UO note of the MLA of so and so was not the only ground on which the order of transfer dated 15 November 2022 insofar as the petitioner and the respondent number 4 is concerned was modified, but the same was done on an overall consideration of the public interests and the administrative exigencies having regard to the competency and the experience the respondent number 4 has as DDSC poster. He therefore has submitted that since the respondent authorities, he therefore has submitted that as it is the prerogative of the employer to transfer and post the employee wherever it is deemed fit, and in the instant case, the reasons reason for modification of the earlier order of transfer dated 15 November 2022. On the basis of your note of the MLS transfer as well as the how did I start the sentence? Last sentence. So it's taking into the administrative experience of the resp- the petitioner cannot have right to be posted at a particular place. And which of the employees to be posted where? It is entirely within the domain of the employer. And as such, the petitioner cannot have any right to be posted at SDDSC Leparada.
Non-improvement.
Huh?
The first ground which I urged was non-improvement of the MLA.
That I'm saying so.
Sorry, madam, I have not.
He has further argued that since the basis of the petitioner's case is the UO note of the MLS censor. Your argument is what? In the absence of MLA,
behind his back,
not maintainable.
Not maintainable, and behind his back, no order can be passed.
Since one of the ground for assailing the interim order dated 20 April 2023 is the note, is the UO note dated so and so by the MLA so and so. And the said MLA having not been implemented as a respondent. The read petition is not maintainable. Any other?
And then that, I think that is.
That will do. In Jamo's contention, you write another one. Mr. Jamo has got a contender that even if the respondent authorities had issued the appeal order dated 20 April 2023, acting upon the UO note dated so and so put up by the MLA so and so, the same will not vitiate the order dated 20 April 2023. As the MLA, as a representative of the public, as the right to express the grievances on behalf of the people. In support of his contention, he has relied on the decision of the Supreme Court and Mohammed Masood, etc. Mohammed Masood, Ahmed Masood, State UB and others, 2007 at SCC 150. Tribal contentions advanced by the Council for the Parties have received due consideration of this court. Upon hearing the Council for the Parties and on perusal of the materials in the court, it has remained undisputed that the petitioner was transferred as DDSC Leparara by an order dated 15 November 2022 issued by the Commissioner of Education, Government of Supervisors, by number so and so. And the respondent number 4 was transferred as principal. And you write this GHS Kanubari 8. Was respondent number 4 was transferred from who was working as a DDSC SEPA, his coming district, was transferred as principal Danikunya GHS School 0. The order of transfer dated 15 November 2021, insofar as the petitioner is concerned, as DDSC Laboratory, was, however, to take effect. In the transfer order dated 15 November 2022, it was however provided that the petitioner will join as DDSC Leparada in the last part of April 2023. There is also no dispute on the facts that the impugn order dated 20 April 2023, whereby The petitioner has been written as Principal GHS Kanbari, Longding District, and the respondent number 4 has been posted as DDSC Basa in modification of the earlier order of transfer dated 15th November 2022 was issued inter alia on the basis inter alia having taken note of the PO note dated 28 February 2023 issued by the put up by the MLA 29 Basar ST Assembly Constituency poster. The UO note dated 28 February 2023 put up by the MLA 29 Basar ST Assembly Constituency is reproduced herein below. Poster at page 49. On perusal of the UO note dated 28 February 2023, it appears that the MLA 29 Basar ST Assembly Constituency has made a request to the Honorable Chief Minister to consider the transfer and posting of the respondent number 4 as DDSC Leparada District on the ground that the respondent number 4 is a very sincere and good administrator in education sector. And that he had already served as a deputy director of school education in many districts under Arunachal Pradesh. Poster. Apart from the above, it has also been expressed in the UO note that the general public of Leparada district also appraises him for the transfer and posting of the respondent number 4 as DDSC of Leparada district. Accordingly, on the basis of the above factor, a request appears to have been made for posting of the respondent number 4 as DDSC Leparada on public interest. Full stop. In so far as transfer and posting of the employee is concerned, it is a certain position in law that an employee cannot have a right to be posted at a particular place of his choice. And it is entirely within the domain of the employer to post the employee. It is entirely within the domain of the employer. Employer as to who would be posted in which place. Full stop. But when it comes to the modification of the earlier transfer order issued, an employer can, the employer can modify the earlier order of transfer issued only for the reason, only for justifiable reason. Only for the reasons adequate and justifiable. Also, the present case is one such where the order dated, where by the improved order dated 20 April 2023, the earlier order of transfer dated 15 November 2022 is sought to be modified insofar as the petitioner and the respondent number 4 is concerned. Also, the reason for modification of the earlier order of transfer dated 15 November 2022 by the order dated 20 April 2023 is also not in dispute, which is stated to be the UO note dated 28 February 2023, put up by the MLA 29 Basel ST Assembly Constituency, requesting the competent authority to transfer the respondent number 4 as DDSC, Laparado District, Portion. district. And also the competency and suitability of the respondent number 4 within bracket according to the respondent authorities for posting of the respondent number 4 as DDSC laboratory district. In view of the above, what now calls for the determination of this court is whether the UO note dated 28 February 2022 put up by the MLA 29 Basel ST Assembly constituency for posting of the respondent number 4 as DDSC laboratory district was a reason adequate and justifiable, adequate and justifiable for modification of the earlier transfer of date 15 November 2023 by the order dated by the MP order dated 20 April 2023 insofar as the petitioner and the respondent number 4 are concerned. Full stop. Since the respondent authorities in the counter affidavit have not denied that one of the factor for one of the ground for modification of the order of transfer date, early order of transfer date in November 2022 was the UO note put up by UO note dated 28 February 2023 put up by the MLA 29 Basa ST Assembly constituency. What did I say? Since the state respondents have not denied. Repeat yourself. Repeat yourself. What could? Okay. The you are not dated 28 February 2023, which has been extracted here in above. Maybe examine. The by the you are not dated 28 February 2023 put up with ML it is seen which has been accessed here. It is seen that the MLA 29 Basel State Assembly constituency has put up a note requesting for transfer and posting of the respondent number 4 as DDSC laboratory district on the ground that the respondent number 4 is very sincere and good administrator in education sector, and that he had already served as a deputy director of school education DDSC in many districts. That apart, the general public of laboratory district also appraises the MLA that respondent number 4 be transferred and posted as Leparada district. Full stop. The MLA 29 Basar ST Assembly Council is stated to be a local MLA of Leparada district. Full stop. In the case of Mohammad Masood Ahmad versus State of UP and others, 2007 at SCC 150, Honorable Apex Court has held that the recommendation made by the local MLAs and the members of parliament by itself may not vitiate the order of transfer. Full stop. The concerned MLAs and the MPs being the representatives of the people, it is their duty to ventilate the grievances on behalf of the people. Question. There cannot be a hard and fast rule that every transfer at the instance of an MP or MLA would be vitiated. First off, it all depends on the facts and circumstances of an individual case. Question. Taking note of the law laid down by the Honorable Supreme Court in Mohammad Masood Ahmad Super, you were not put up by the MLA 29 Basar ST Assembly Constituency dated 28 February 2023, requesting the competent authority for transfer of the respondent number 4 as GDS Leparada district cannot be faulted with them. Accordingly, even if the respondent authorities have modified the transfer, the earlier transfer order dated 15 November 2022 by the imperial order 20 April 2023, acting on the you are not put up by the MLS and so dated 28 February 2023, that by itself cannot be held to vitiate the order dated 20 April 2023. Full stop. Apart from referring to the UO note dated 20 February 2023 put up by the MLS and so, and the reasons not assigned while issuing the impugn modification order dated 20 April 2023, the petition, there is no allegation of any malafide. There is no allegation of any malafide exercise of power by the respondent authorities in issuing the impugn order dated 20 April 2023. It is again a well-settled position of law insofar as the judicial review of the order of transfer and posting is concerned that unless the order of transfer is shown to be an outcome of malafide exercise of power or violative of any statutory provision or passed by an authority not competent to do so, an order of transfer cannot be interfered with. in the absence of any allegation of malafide exercise of power by the responding authorities in issuing the order, the order dated 20 April 2023. I am not inclined to interfere with the implementing order dated 20 April 2023, even if the said order has been issued by the respondent authorities, acting on the basis of the UO note dated 28 February 2023, put up by the MLA 29 Basar ST Assembly Constituency, having regard to the law laid down by the Honorable Supreme Court in Mohammed Masud Ahmed Supra. In view of the above, I find no merit in the stated petition, and the writ petition is dismissed. Yes, Mr. Bro. Yes.
My lord, I may be allowed to withdraw this matter.
Why?
My lord, there is no case against me.
Huh?
There is no case against me. My lord, earlier I have gone to the IO, my lord.
Huh?
However, my lord, they are not recorded my statement, saying that, my lord, there is
no case against you.
Yes, my lord.
Then why did you approach this court? You approached the court, it is little bit understandable. But then why did this court grant you an interim protection?
My lord, I was told that, my lord, there is case against me.
You were told. There was no there was no any apprehension by the petitioner. Huh?
Yes, ma'am.
Apprehension by the petitioner is absolutely not there, which is the very basis for court appeal.
Yes.
Now you have realized, but the court was but the court readily granted you an interim protection. Mr. Magedi.
Yes, ma'am.
So we should impose cost on you. You have wasted the court's time. You have wasted the PP's time. They all work on public money.
Well, it was not done.
How much?
Intentionally.
How much? You have taken the court for a ride.
Yes, my lord.
You have taken the court for a ride. You were so persuasive that you have been granted interim bail on furnishing a bond of rupees 10,000.
Well, there was an FIR, my lord.
FIR was against somebody. Who is for the PP? Yes.
Yes, Your Lordship.
Can anticipatory bail be withdrawn?
Your Lordship, any criminal case, Your Lordship, there is no any provision to withdraw for the anticipatory bail. However, Your Lordship, if they are saying that there is nothing against them, Your Lordship, then that has to be looked into from the case diary, Your Lordship. Because earlier, the court has granted the bail on the basis of the apprehension. So,
do you have the case diary?
No, Your Lordship.
You produce the case diary.
Okay, Your Lordship. Maybe day after, Your Lordship.
Mr. M. Margedi, you on the next date you tell this court whether anticipatory bail application can be withdrawn.
Yes.
Margedi, learned counsel for the petitioner, Mr. T. Ete, and APP for the state. Mr. Margedi, learned counsel.
Your Lordship, before the petitioners proceed, Your Lordship, I would apprise the court that, Your Lordship, this matter is pertaining to sexual assault, Your Lordship. And as per the High Court rule, Your Lordship, the live streaming of the live streaming on the cases of sexual assault shouldn't be, Your Lordship, done, Your Lordship.
But where do we have the control?
Your Lordship, proceedings shouldn't be live streamed.
Yes.
Your Lordship, this is a notification, Your Lordship.
Yes.
Your Lordship, this is a notification, Your Lordship.
No, who is the, yes. Who is the
my occupied land
By whom?
by the private respondent.
They have constructed over your land.
Yes.
Then how the writ will lie?
Lordship.
How the writ will lie?
Lordship, I have applied for the allotment of my occupied land, but my application is not being considered by the respondent authorities. And during pendency of my application, the private respondent number 4, 5, 6, and 7, they have constructed the illegal structures over the land in question.
Yes. Can it be disposed of?
But sometime maybe granted by.
You are for whom?
I am appearing for respondent number 5, madam.
Respondent number 5.
Yes, ma'am.
You are one of the respondent who has constructed over his land. Huh?
My lord, I have purchased the land from respondent number 4, madam.
You have purchased the land from 4. Who is for 4? Who is for 4?
It's a private respondent.
4 is not represented.
In fact, Lordship, the service has been completed. Although the service has been caused to the respondent number 4, in the meantime, I am being informed that the respondent number 4 has died.
Died?
Yes.
Then you may have to bring. Who is respondent number 4, by the way?
Respondent number 4 is the actual owner of the land in question. He was allotted a land measuring 96 square meter. But now, the land where the construction has been carried out by respondent number 5, 6, and 7 is above 96 square meter, where my occupied land is being laid.
So can this writ petition be adjudicated in the absence of respondent number 4?
Lordship, is if this honorable court allow, I might be allowed to arraign the legal hire of respondent number 4.
Okay. So we'll adjourn it by 2 weeks, 3 weeks.
2 weeks. No?
2 weeks, okay. And the prayer of learned council applicable parties listed after 2 weeks.
Obliged.
None appears after 8 weeks.
Well, I'm extremely sorry, this few minutes back, I checked the file noting, and it's that I have not taken a step upon respondent number 5 in this. So, I humbly phrase that I may be given time.
This is not very unusual in your case.
I'm extremely sorry for this. Moreover, your respondent, I have to file their counter affidavit.
Mr.
Ivan,
counsel, just in view of the office note dated 1/7/2023, Mr. Ivan, London counsel for the petitioner, press for any granted 1 week time.
Yes.
To take steps upon respondent number 5 and 6. Listed after 8 weeks.
Hello.
By what way, sir? Registered post.
In this case, my lord, we have taken steps upon the respondent number 2 on 1st July 2023.
Yes.
As per last order. Meantime, my lord, may I pray scan copy of LCR may be called for.
Who is respondent number 2?
Is the informant.
Informant.
Yes, ma'am.
Why LCR is necessary?
Because, my lord, we are assailing the framing of charge. Our case is that despite of there being no any material.
What is this interim order?
interim order is, framing the charge against this petitioner.
Okay.
Despite of there being no any material attracting section 4 of POCSO Act.
Mr. K. Tamal and common petitioner, and Mr. L. Ravi. Granted FEP for the state. Our service report on respondent number 2 is indicated in 17, office note dated 17/2023.
Service report is
LCR will be required.
required.
Scan copy of the Excel also.
It has been stayed also
Yes, my lord.
till 9/6/2023. This is the order framing a charge.
Framing a charge,
Still remain stayed.
my lord.
So that means they can't be any trial.
My lord. Prima facie, my lord, this honorable court was of the opinion that from the records, it does not disclose any materials attracting section 4 of POCSO. That is my case.
Then why is scan copy? You can call the record itself.
In that case, elsewhere, my lord.
Call for the answer.
Interim order, maybe, my lord.
Interim order pass warnings and continue till the next date of listing.
Next day.
Huh?
Next day.
This after 4 weeks.
Highly.
Alright.
Yes.
Only 5 minutes.
Only 5 minutes. What is to be done?
My honest near. Have no difficulty. It can be fixed for tomorrow.
See, then you take it up after the decision of the Supreme Court.
That would be better, you know. That would be better. That would be my humble submission. No, it can be, my lord.
Because
Yes, my lord.
in that order,
My lord.
I think two issues, two or one or two issues are still to be determined.
Yes, my lord. 2 issues are here.
You know that?
Yes,
So if they fail in the Supreme Court,
my lord.
then that election petition is not yet disposed of. Is not it?
Yes, my lord.
It will be listed along with this.
My lord.
Then we will dismiss this and answer the issue.
Exactly, my lord.
Suppose they succeed.
My lord.
Suppose they succeed and then the order passed by this court declaring its election void.
Yes,
then what happens?
My lord,
Then nothing remains to be
nothing
done.
remains.
Then
You
nothing
must-
remains to be.
Then nothing.
So therefore, is not it?
Yes, my lord.
So we'll list it after, when it is fixed for hearing,
6th of September.
we can fix it in September sometime. Is not it?
My lord may fix it after say 10th or 12th of September. By that time, position would be clear. Because if the hearing is done on 6th itself, hearing is concluded and judgment reserved, we can apprise, my lord, that this is
So
what
we'll
the
say
status is.
on the prayer of council parties listed after 10th of September.
Yes.
Okay. On the prayer of 11th.
Because if judgment is delivered, we can very well inform the court. If it is CAV, then either way.
Mr. You had filed on IA.
Yes, Miss Case is filed by me. Because, my lord, if the IA is allowed, he will, his client will be declared elected. So nothing would survive. He has gone into the very maintainability.
If his IA is allowed
Yes.
here, if his IA is allowed here, declaration will not be here. Declaration will have to be made in there.
Yes.
So which order is in consideration of the Supreme Court?
Yes.
And I don't know why the Supreme Court has not called for the record. Record would not be necessary.
They may not, because the Supreme Court will go by the evidence and everything. All that is part of the paper. So that is why they will not call for it.
What is that IA?
In this case, 01 of 2023.
001, no?
01.
Okay. We'll pass order in IA. Mr. No, this is not the one. 01 of 20?
23.
23, this is 21. Okay. ये इलेक्शन पिटिशन को नहीं देना है, इसमें रिक्रिमिनेशन पिटिशन है Mr. H. Lampu, the only counsel for the applicant. Applicant's election petitioner and Mr. P.K. Tiwari, senior counsel for the respondents, secretary and candidate. On the prayer of legal counsel appearing for the parties to this application after 10th of September 2023.
This 43 is my lord IA. We have filed for alteration modification of the ex parte interim order passed by this honorable court on 9/6/2023. That is page 8.
Yes.
Page.
You'll file objection.
Yes. Page 8 is the order that we are praying for modification. Because my lord, this case is second appeal. And without even framing the substantial question of law or admitting the appeal, the status quo order is.
Yes, how can it be?
Therefore, this needs to be vacated.
What is the substantial question of law? We'll vacate this order. Mr. K. Tamalame, counsel for the applicant.
We'll find it next.
See, in second appeal, once you see, notice is not issued first. You have to formulate the substantial question of law. If you find that you have raised a substantial question of law for determination of this court, then only after framing that notice will go to the. Here, what you have done is you have not formulated the substantial. You have stated issued notice to him. What will he do here?
And then we have cleared in our application that substantial question has been cleared. In the meantime.
No, do you agree with the proposition which I have said or not?
That is the correct proposition. CPC also same.
Mr. K. Tama, learned counsel for the applicant. And Mr. K. Davi, learned counsel for the opposite party. So, appeal. This is an application filed by the applicant for vacation of the order dated 9/6/2023 passed in regular second appeal.
Yes. 5 of them. Regular second appeal.
Oh,
5 of
okay. Passed in RSA number RSA 5 of 2023. However, while issuing notice to the respondent in the RSA, an interim order to the effect that the parties will maintain status quo till the returnable debt has been passed. So the learned counsel for the applicant has contended that no interim order could have been passed by the court in an appeal filed
Second
under,
appeal. In a second appeal under section 100.
in a second appeal filed under section 100 of CPC 1908 without the second appeal having been admitted after formulation of the substantial question of law. Having heard the one, having considered the contentions raised as above, this application stands alone. And just before that, on perusal of the order dated 9/6/2023, passed in RSA 5 of 2023, it appears that notice to the sole respondent in the second appeal has been issued without formulation of a substantial question of law involved in the appeal. And thereafter, an interim order of the status quo has been passed. First, upon consideration of the contention raised by the petition, by the applicant, and in view of the settled position of law that second appeal filed under section 100 of CPC 1908 can only be admitted on formulation of a substantial question of law arising for determination. In that case, this interlocutory application is allowed, and the order of the status quo and the interim order dated 9/6/2023 to the effect that the parties will maintain the status quo till the returnable debt is hereby vacated. I still dispose. Then
Main case.
in just a moment.
Main case may be listed for admission.
Main case. Mr. K. Davi, the learned counsel for the appellant, you will appear. And Mr. K. Tama, learned counsel for the sole respondent. Next week. 24.
Yes, one.
Okay. On the prayer of Mr. David on the council for the appeal, listed on 24th July for admission hearing.
Hello.
Okay.